The Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning and welcome to the Appeals Court. I'm Justice Mead. With me today are Justice Nyman and Justice Walsh. Will be the panel on all of the cases to be heard today. Each side gets 15 minutes. You needn't use all of your time. We do not entertain rebuttal. We have read everything. My best advice is to get right to the point. With that, I'll call our first case, 24P 1159, Fuss and O'Neill versus Canterbury Cultivation. Mr. Curtis.
Thank you, Your Honor. And if it may please the court, Robert Curtis for the appellant Sean Morrison. And if you'll indulge me for 30 seconds, yesterday I read the court's most recent newsletter about the retirement of Justice Englander. And the story referred to Justice Englander's habit of not only asking what the law says, but why it says that. And as I was preparing for this oral argument, it occurred to me that this case really requires that type of inquiry. Why do the rules of professional conduct permit the disqualification of a lawyer on conflict of interest grounds? Why must the court treat disqualification as a drastic measure, which is only exercised sparingly? Why is a searching review of the facts necessary before disqualification may be ordered? And answering the whys to these questions will likely guide the analysis on the issues of this case.
So I have to interrupt you. Much like Justice Englander, I like to ask a lot of questions. So
He doesn't hit reply to all on the
it does distinguish us. The standard of review in this case, both parties have it listed as abuse of discretion. So let me ask you this question. Is determining whether there is a concurrent conflict of interest under Rule 1.7 a question of fact or a question of law? And I ask this question because the argument here is that disqualification was mandatory. So how can the standard of review be abuse of discretion? Shouldn't it be clear error or de novo?
Well,
In this context.
Yeah, I think like most questions that probably end up before this court, there really is some mixture of facts and law involved. And so when you have that combination, there is a degree of discretion that needs to be exercised because the judge has to look at those facts and determine whether or not they fit the structure or the matrix of the law. So, and certainly an error of law constitutes an abuse of discretion. So I think the first thing we need to do is look at the law in this case and what it's, not only what is it intended to protect against, but how is it structured. And so when you start with that look, you realize that really in a case like this, where you've got the two sole owners of a closely held corporation litigating against each other, each separately represented by counsel, obviously one or the other at various times is going to be in control of the company, but the litigation is actually the two owners against each other. And that's what we have here. But then you have a judge saying that there's a conflict of interest between one lawyer and the company. So you have to look at, well, what is that conflict of interest? I mean, interest is right there in the name, conflict of interest. So what is the interest this company has in this case? And there really is none. It's these two owners litigating against each other. It's Mr. Morrison, well, I should say Mr. Buchholz, since he initiated the claims against Mr. Morrison, versus Mr. Morrison. And that's it. And it was Mr. Buchholz, between the two owners, who fired the first shot by filing these initial claims. I mean, initially they were, they were in-pleaded claims because there was an original plaintiff who's no longer in the case. But so he fired the first shot when he was in control of Canterbury. And so, he continues to argue to this day that those claims were therefore direct claims because I was in control of Canterbury, therefore I was empowered to Does
it really matter whether the claims are direct or derivative in the context of a closely held corporation where there's no evidence, at least that I can see, that any corporate formalities were observed, where it's really just a two-person entity?
Right. I would say no, it doesn't. If it does matter, though, I think you see that the nature of these claims were ultimately derivative, especially when Mr. Buchholz ceded control of the corporation to Mr. Morrison, because that's the definition of a derivative claim is, the stockholder or the shareholder is no longer in control of the company but wants to assert a claim on behalf of the company. But ultimately, it doesn't
unlike
matter.
your claims, he didn't follow Rule 23.1, didn't have
Correct.
a verified complaint, didn't seek permission, et cetera.
Correct. And I mean, I assume his argument would be, well, I was in control of the company at that time, so I was empowered to make these direct claims. But again, I don't think it really matters ultimately. When you look behind the curtain, it's Buchholz versus Morrison. Canterbury is just there sort of tied into it because if there's a ruling, Canterbury as an entity will be bound by whatever that ruling ultimately is, but there's no separate interest there.
Who, and I'll ask this question of your brother, assuming for the sake of argument there is a conflict, who decides who appoints counsel for Canterbury?
That's a great question, and I don't know how that would be determined. I mean,
Wouldn't it be Morrison under the standstill agreement?
Probably, correct, yeah, but then you get into sort of the ridiculousness of this situation. So Morrison can hire Attorney Bierwas to represent himself, and then he can hire Attorney Smith to represent the company.
Well, that begs another question I have. You don't make the argument in your brief, and I don't see you make it below, that Bierwas could represent Morrison or could continue to represent Morrison, but someone else should have been appointed to represent Canterbury, which we see all the time in corporate cases. So since you didn't make it, it's waived, but I'm just curious, why wasn't that argument made?
Well, so it wasn't made because I don't think it's necessary. I don't think there's any reason to disqualify Attorney Bierwas from representing either of these parties in this particular circumstance, because the so-called representation of Canterbury is just as a nominal party, it's a formality. There's no actual interest she's representing there. As far as suggesting that it was waived, you're right, it wasn't raised below, and it wasn't a primary argument in our brief. I mean, we do cite in our reply brief, because a number of the cases our opponents cited involved cases where there was a perceived conflict, and the courts ultimately held, okay, so the attorney is disqualified from representing the company, but not the individual. And we did cite those cases in our reply brief. So there's some authority there. I mean, granted, it wasn't raised below, and I understand that. But again, I don't think it needed to be raised below, because I don't think we have a situation where there's even a conflict here. Because again, it goes back to what was the company's interest in this case. There is none. It's these two gentlemen litigating against each other. And that's really all there is to this case, really. And
can I interrupt for a moment?
Sure, absolutely.
I mean, first of all, I'm impressed that anyone read our appeals court news outside of the present company. So thank you for reading it. Actually, it's good stuff. Your argument is very impressive. It just, in my opinion, doesn't seem to hold water if I don't agree with you that Canterbury is just kind of this blob in the middle, right? For lack of a better word. So sure, if it's two people dueling with one another about control, makes sense. But the judge didn't find that. And part of this mixed question, if you will, of fact and law appears to be the judge's determination that because the allegations against Morrison were that he was taking business away and diverting and doing his own thing, that there were separate harms to the entity than to the individual. Can you address, if we disagree upon that, what's your argument that this decision is still improper?
Sure. So there's quite a bit to unpack in that question, and I'll try to do it as best I can. But I think the first thing is, you said that the judge didn't find what we're asking her to find. She didn't find anything. There was no evidence taken other than, documentary submissions with a motion. But it was not an evidentiary hearing. There were two hearings. No witnesses were sworn. No no exhibits were marked. No findings. And even if you read her decision, I think, I don't have it off the top of my head, but we cited it in our brief. She uses the word find or finding like tangentially on one or two minor points. She didn't make findings, and that's part of the problem, because in a case like this, you need to examine the record very carefully and then make factual determinations that support the ruling, and she didn't do that here. Absolutely an evidentiary hearing was warranted here if she was going to disqualify Attorney Beerwas. And if you look at the cases where that's happened, they almost across the board at least had some sort of evidence received in.
Is there any dispute that after the LLC was formed, that Mr. Morrison at least applied for a competing special permit? Or not special permit, but a competing permit? As far as I can tell, that's undisputed. I understand he dropped it, or he withdrew it.
Right.
And I understand you could make the argument that perhaps it wasn't truly competing, but it seems to me that that's a reasonable inference to draw from the evidence, or from the undisputed plea.
You're probably right. I mean, where that wasn't a primary issue, that was really litigated at all. It was just simply alleged. It never really got explored, and I think...
You have the we have the application before us. We have the board minutes before us, or at least they were before the judge. Mm-hmm. So I don't see that as a disputed matter.
I mean, you're probably right where there was no controverting evidence supplied there. But again, it does raise a lot of the questions that you yourself just pointed out. I mean, was it actually a competing, those are questions of fact. But so for the purposes of this appeal, yes, it was a allegation that this judge felt was significant enough to trigger the provisions under Rule 1.13.
I think it's fair to say it's an undisputed allegation.
Okay.
Having read through both briefs and both records, it's not disputed anywhere in the record.
Technically
correct. And I don't think it could be.
Yeah, I mean, that piece of it is correct. I mean, it's not a proven allegation, and again, I think there are nuances there that would need to be explored if there was an evidentiary hearing held on that.
Assuming arguendo it's undisputed, how is that not at least arguably a breach of fiduciary duty to the LLC? Unless, of course, again, you're arguing that there really was no LLC. I mean, it was just in name only.
Well, and
you make
correct,
the argument that it's nominal.
Correct. But that's really, I mean, you don't get to the serious allegation of wrongful conduct piece of it unless if there's a conflict of interest, which is Rule 1.7. So that other piece, the serious allegation, that's Rule 1.13, which the commentary that was cited basically says in most cases you're still, the attorney for the controlling shareholder is the attorney for the company and all of that, and only when you have these things could there potentially be a problem, but you still turn to Rule 1.7, and that's in the comment. You still have to do the 1.7 analysis first. And if you do the 1.7 analysis first and there's a conflict, then these other, inquiries come into play. But you still have to do that first. And when you look at Rule 1.7 and you look at what exactly, constitutes a direct adversity conflict of interest, there has to be an interest there. There has to be. And there's this whole line of cases, the Aurora case line I cited, the Seifert case, which honestly, Attorney Cooley found that one and it made it into our reply brief, but not into our primary brief. But that was 1964. There was a court saying, there's no conflict here when you've got this sort of shell company that's standing in between the two actual litigants.
Are Aurora and Seifert your best cases with respect to Rule 1.7?
I think so, correct. I mean, there are other cases that cite Aurora, but they kind of, I call it the Aurora line because Aurora was the first one and then the rest of them kind of followed that. But there is a trend to follow it. I see I've used up my 13 minutes and I want to give Attorney Cooley an opportunity. Okay, thank you.
Mr. Cooley.
Thank you, Your Honors. May it please the Court, Edward Cooley for Canterbury Cultivation Cooperative, LLC. I'll be very brief. I'll not repeat what Mr. Curtis said, but not only does Canterbury not have an independent interest, as Attorney Curtis has set forth, but Mr. Bullhold knew at all material times that there was no independent interest, and he conducted himself and the litigation accordingly. His claim in Count 5, if you go to the Appendix 1 at page 123, paragraph 52, is that Mr. Morrison was allegedly operating a potential competitor. That's the claim. That's a claim that was filed at the very outset and then litigated for 4 years. And who litigated that claim? Mr. Buchholz litigated that claim through Mr. Buchholz's lawyer. Right up, all discovery was conducted, they got right up to literally the day trial was to commence. So all issues by that point are fully joined, the case is prepared for trial, and it was prepared not by an independent counsel for Canterbury, but by Mr. Buchholz's lawyer. And that is the clearest acknowledgement you have that Mr. Buchholz's interest is what was at stake and not Canterbury's. Canterbury didn't have an independent interest outside of these two people fighting, and the proof is actually in the pudding, so to speak. If you
But aren't
look,
both parties bringing claims through Canterbury?
both parties,
Both parties.
we assert that both parties filed derivative claims. Again, whether they're derivative or not doesn't really matter in the context of who had the interest. But the point I'm making is that with respect to count 5, it was Mr. Buchholz's lawyer who was pursuing that claim all the way through. And if you want to know what the parties thought, whether they ever perceived that there was a conflict or believed it, look at what they did. That's the surest sign of the existence of a conflict. He never thought there was a conflict, and he pursued it accordingly because there wasn't one. He knew that the interests that were being implicated were his own, and that's why he pursued it. And if you look at the appellee's brief, they attach deposition testimony in which Mr. Buchholz's lawyer is cross-examining Mr. Morrison on the issue of the Fitchburg application.
We've read through it, I assure
and that
you.
was in 2022 that deposition was taken.
We're going to have to leave it there.
I'm sorry?
You're out of time.
Oh, I was telling me, I
counting
apologize,
up.
Your Honor. I thank you for your patience.
You owe us 30 seconds on your future argument.
I'll give it back some other time.
Oh, no. Much appreciated, thank you.
My appearance sheet does not have, is it Fioravanti or Vins?
Attorney Viennes, Your Honor.
Okay. Go ahead.
May it please the Court. Good morning, Your Honors. David Viennes for appellees Robert J. Bujold and 310 Broad Street 2 LLC. We ask the Court to affirm the trial court's disqualification order because appellants have not demonstrated an abuse of discretion by the underlying court. The Court properly found an unwaivable concurrent conflict of interest under Rule 1.7 of the Mass Rules of Professional Conduct. I do want to begin by following up on my brother's comments at the end of appellant's argument. Count 5, it's undisputed on the record of this case, count 5 of the third-party complaint is a direct claim by Canterbury against Mr. Morrison.
Not what the judge found.
Well, the judge, there's an error in the court's footnote 1, and it's not material where the judge, and it's a footnote, so I would suggest that it was not intended to be a finding or ruling, where the judge refers to count 5 as a derivative claim, and I think the judge overlooked the fact that that is in fact a direct claim, and below.
Move to reconsider or move for clarification?
So it was unnecessary because the only impact that would have is if it's a derivative claim, then the court looks at 1.7, but then it also looks at 1.13G, and the court's decision makes clear that if you're looking at 1.7 and it's a direct claim, case closed, concurrent conflict of interest, the court doesn't need to go to 113, but if it's a derivative claim, then the court can look at 1.13G, and that's what addresses when an attorney can represent a corporation and an individual accused of wrongdoing, and it says, if it's a derivative situation, you have to look at Rule 1.7 to see if it passes muster. But so it's not important that the judge made that mistake because whether it's direct, we never get to 113, and the court says there's direct adversity.
Argue that if it is derivative, it doesn't matter in the end. I
And
get
it's
that.
unclear if the judge did that to assume arguendo, but in any event, we have enough in Judge Horatius's decision to say if it's direct, 1.7A is dispositive. If it's derivative, 1.13G is dispositive.
So the judge disqualified Attorney Biroz from representing both parties. What if she had just disqualified her from representing one or the other?
She couldn't have done that
Why?
because of Rule 1.9A of the Rules of Professional Conduct. That rule states that where a lawyer has formally represented a client in a matter, they shall not thereafter represent another person in the same or a related matter in which the person's interests are materially adverse to the interests of the former client unless there's informed consent in writing. So the judge found there was a conflict of interest. There was direct adversity between Canterbury and Morrison that required disqualification. So at that point,
Doesn't there have to be a determination, and perhaps I'm misreading the rule or misunderstanding, doesn't have to be a determination that the lawyer either gained information through the representation or that there is some sort of problem? It seems to me that all of the time we have lawyers representing, whether it's in closely held corporations or otherwise, representing both the entity and an individual. The potential conflict or the conflict gets brought to the attention of the attorney, and then new counsel is brought in. I've had that happen in practice. I've seen that happen many times in court. So, but maybe I'm misunderstanding the rule. You're telling me, nope, the second you represent both, you're out on both.
because it's in the same proceeding. This wasn't.
Right,
Trinity
but
Bureau was-
what information could they have gleaned from Canterbury that they couldn't have also gleaned from Morrison? When you're
Yeah.
dealing with a closely held corporation consisting of two people, where as far as the record shows, there was no observation of corporate formalities. That doesn't make
yeah.
sense to me.
1.9A, and perhaps it's a different section of the rules, but 1.9A is mandatory. The language is not open to interpretation. It says a lawyer who has formally represented a client in a matter shall not thereafter represent another person in the same matter. There's no discretion, there's no discussion about confidential information because
Are there any cases on 1.9A interpreting it?
I don't believe any are cited in the record, but I think 1.9A was cited in the original disqualification motion. But in any event, this would be as if one attorney came in and represented the plaintiff and the defendant in a case that are on the opposite sides of the V. It's exactly the same thing here because we have a direct claim that Canterbury filed in its own name against Morrison, and that's under 156C, Section 55. That allows LLCs to sue in their own name or to be sued in their own name. And then 156C, Section 56, talks about derivative claims. Mr. Morrison's claim in Count 5, Canterbury's claim in Count 5 was never a derivative claim, nor could it have been a derivative claim. If you look at the International Brotherhood of Electrical Workers case, 476 Mass 553, that case, like many other Massachusetts cases, discusses the difference between derivative claims filed for corporate harm and then individual claims filed by members of closely held businesses for their direct harm. Massachusetts law is, and it's well established, if an owner or member of a closely held business is alleging harm to the corporation, and they don't have control of the entity to file suit on behalf of the entity in its own name, they have to seek redress for the corporation through a derivative claim. That's black letter law. That's well settled. In this case, Morrison, yes, he asserted derivative claims against Mr. Morrison, against Mr. Bujold because he was not controlling the entity. But at the time the third-party complaint was filed, Mr. Bujold was controlling the entity. You look at that pleading, Canterbury is a direct party. They were sued by Fuson O'Neill. That's what started this whole litigation, an engineering firm that was doing work for Canterbury. Mr. Morrison stopped paying the firm because we found out later that he was pursuing a separate competing secret business. That caused Canterbury to be sued. Mr. Bujold was a registered agent at the time. Mr. Morrison had walked away from the entity at that time. And in the record, at page 320 of Record Appendix 1, there's a letter from Mr. Bujold to Morrison in January of 2020 where he basically says, you've walked away from the partnership. I consider our partnership over. In May of 2020, at Record Appendix 1, 322, Mr. Bujold actually sent a no trespass letter to Mr. Morrison, and what led to that was he was taking items from the business, he was allowing
But
workers to...
before you run out of time, the standstill agreement is still in effect?
It is, and we sought to
Who
remove
represents, sorry, who chooses representation, assuming that we agree with you? Who chooses the new lawyers for
that. Kenneberg?
Canterbury and
I think
Morrison?
the two owners would need to jointly...
Under the standstill agreement, it seems to me it would be Morrison.
I believe, well, the standstill agreement was only intended to be a temporary agreement.
Well, you just said it's still in effect.
Yes.
And
It was
and
challenged below, and the court, we had moved to rescind it, and this...
Joe acknowledges Morrison is the sole voting member of Canterbury with sole authority to act on its behalf.
Okay. It was sought to be vacated below. We would seek to vacate that. If it was not vacated, if that permits him to retain counsel, counsel would have to ethically determine whether or not they could take direction from him. And if you look at Rule 1.13G, that's where it talks about a conflict between the managers of an entity and where there's claims against a member for serious wrongdoing, that can create a conflict of interest. So Mr. Morrison, even if he does have authority under the standstill, if the standstill is upheld, a lawyer cannot ethically take direction from him as to the management of Canterbury in the litigation. It would have to be independent decisions by counsel.
How could they ethically take
I think they would.
information from your client, from Bujo?
Well, I think there's no charges of serious wrongdoing against Mr. Bujo that have been established. The court specifically found below that there were serious charges of wrongdoing against Mr. Morrison. But I think the easiest way to look at this case, I think what happened below is that Attorney Bierwas was conflating a direct claim by the corporate entity with a direct claim by an individual. And the Durham case, that's a New Hampshire case that the appellants cite. That case is actually not helpful for the appellants for the reasons they cite to it, but it is instructive to the court for its differentiation of those three types of claims. So I would direct the court to page 44 of the Durham case, and that's where the court says when you have a closely held businesses, there's three types of claims for harms to the company or the individuals. Number one is a direct claim by the corporation for harm to the corporation. That's what count 5 is here. The second type is a derivative claim for harm to the corporation filed by a minority interest holder or non-controlling member. The last type is a direct claim by an individual owner for their direct harm. And the most classic example is a freeze-out claim. That's individual harm to a owner. That's not corporate harm. So that case actually distills those three different types of claims very well. I couldn't find a good case in Massachusetts where they talked about the three different types. Typically, the cases talk about, is it direct, individual direct, or is it derivative? And the fight is usually about whether or not an individual can make a claim directly, or whether it's derivative, or whether they've followed Rule 23.1, or whether they've verified under 23.1. But the Durham case at page 44, I would suggest the court look at that. And that was what was overlooked below by Attorney Bierwas. And I will also note, Your Honors, my firm became involved in this case weeks before trial. Prior counsel, Attorney Ray, was terminated by the appellees a couple of weeks before trial. The case was in a mess and in shambles. We couldn't obtain the case files. We never obtained the actual complete case files. We patched together the record through the docket. Once we got involved in the case, it was a very brief continuance of about 2 months. There were negotiations. And once those failed, we prepared in earnest for trial. As part of that preparation, we obtained a document that was never produced in discovery.
Yeah, I don't know that I'm buying that this was, entirely new information. Well, you put Record Appendix page 1, Volume 1, page 119. Your allegations back in 2020 were Morrison now operates a business in direct competition or applying for license from the Cannabis Control Competition in order to enter into such direct competition with Canterbury.
It was a different entity. There was a retail, he sought an application for a retail dispensary, which is different than the cultivation business. Cultivation.
Was Canterbury a cultivation business?
Canterbury was to be a cultivation
Canterbury's
business.
to be a cultivation business, then in 2020, they're pleading, again, operates a business in direct competition,
Yep.
applying for a license, which presumably for cultivation.
It was the retail that was being referenced there, Your Honor. And at the deposition.
How was that direct competition with Canterbury?
Well, that wasn't our pleading, but it was alleged that it was directly in competition. That count also relied on allegations that Mr. Morrison had taken equipment from the business that was a harm directly to the corporation.
Can I just interrupt for a moment? Because it's our job to review the determination, in this case by the Superior Court judge, about a particular ruling. But there's a frustrating point about this whole disagreement, is that even if we agree with your argument to some extent, and affirm, if we were to, affirm the decision by the Superior Court judge, Morrison appoints another lawyer, and there's going to be years of litigation about who can represent Canterbury and who can represent Morrison before we even get to the secondary lawsuit and the merits of that. I mean,
I don't think that
this is so
happened.
heavily litigated on the issue of counsel that perhaps my 13 years of being in the trial court, it's frustrating to see attorneys not be able to work out an issue such as this. And I'm not undervaluing the importance of the conflict of interest laws and the importance of having an attorney kind of work from both sides. I'm not doing that, but this all roads leads to more litigation about this little teeny piece of something that I'll be retired before the merits of the case even get heard. But
It is frustrating, Your Honor. We were prepared to try the case, but this issue surfaced days before trial. But I don't think will happen because before this case was stayed, we had moved to vacate the standstill agreement because it was intended to be temporary. That arose after a motion for preliminary injunction was filed. And again, this was prior counsel for appellees. We moved to vacate that. We believe that will be vacated and that we won't run into the problem that Your Honor identifies.
So you just said on the eve of trial, again, you're making the eve of trial, this new information came to light, and you're distinguishing that by saying, well, that was for a retail facility, whereas Canterbury is a cultivation facility. Again, Record Appendix, Volume 1, page 308, the Fitchburg Planning Board minutes. Special permit and site plan review, cultivation of adult use marijuana.
That was the document that was discovered.
Right, it talks
just
about
before
a
trial.
grow facility, and it talks about cultivation.
Yeah,
So
that
it's
was
talking-
never disclosed in discovery. Again, we weren't involved
But again,
until-
you made the argument that this had to do with a retail
No.
setup.
No, when the complaint was originally filed Count 5 was originally filed, Mr. Bujold's attorney was only aware of a retail business, and he alleged it could arguably be
He alleged that
competitive.
it was a directly competing venture.
Correct.
Which would be a cultivation facility, if it's directly competing. And here the minutes confirm that it was for a grow facility,
It was a different entity. There were two different permits. There was a BOT Realty, and there was another entity that was... There were two different permits requested through BOT entities. One was originally a retail. That was the one that was known by Mr. Bujold. Mr. Bujold never knew that, in fact, Mr. Morrison was seeking a cultivation license, and that was at the same exact time that he stopped paying Fusin O'Neill.
Okay.
Thank you. Thank you. Time is up. We'll
Thank
take
you,
it
Your
under
Honors.
advisement. Continuing our cannabis theme, the next case is 25P71, Construction Source Management versus Bellfleur Holdings. Mr. Zapia.
Good morning, Justices. If it may please the Court, Benito Zapia on behalf of the appellants, Bellfleur Holdings and Bellfleur Realty. I'd like to start by addressing the second issue in my brief, and that is the Superior Court's denial of the motion to dissolve the mechanics lien. And as stated in the brief, the grounds for dissolving the lien are based on a knowing and willful misrepresentation as to not only the amount owed on the lien, but to the party that actually is alleged to owe any amount on the lien. As stated in the statement of the account and the notice of the contract, it states that Bellfleur Realty was a party to the contract with Construction Source Management, and that is simply inaccurate. It's undisputed. Bellfleur Realty was not a party to the contract, and the significance of that is Bellfleur Realty is the owner of the property. And in order...
The judge found that the distinction between the two is illusory, and you don't challenge any of the findings of fact.
I do challenge that it is illusory. As stated in the original filings with the Superior Court, Bellfleur Realty is a property management company, whereas Bellfleur Holding, the tenant, is a intellectual property company. They have distinct purposes. They are not controlled by one another. Although they have overlapping managers, they are separate and distinct entities. One is a tenant on the property, Holdings, and Realty is the owner of the property, and therefore they have different interests in the property. Holdings is the one who actually holds the license to cultivate cannabis on the premises. Realty, the owner, does not hold that license. So I'd respectfully submit that they are separate and distinct entities.
So let me just begin the questioning that I had, if you don't mind, and we can stay on that second issue. First of all, you agree that the standard is abuse of discretion?
Yes.
Okay. And I think your argument is in part the difference between 2.2 million and 1.6 million, because strict compliance is required, that somehow should result in the dismissal of the lien, right?
Not only that, Your Honor, but the fact that Realty wasn't even a party to the contract.
But that's one issue, is this kind of change of a significant amount given strict compliance, should result in the judge dismissing the lien. Secondly, because I shortcut it, R was never a party, and so it should be dismissed just outright, because R was never a party to this, and this was a willful and intentional misrepresentation. That's only if we don't accept the privity argument, correct? So in other words, if H and R are one, in your complaint you answer as BF entities even, if they're all just one big happy family, then what's the abuse of discretion?
Well, I would say the abuse of discretion, Your Honor, is the fact that Realty is the owner of the property, and they were never a party to the contract. That's undisputed.
Right. But if there's privity between the parties?
There is not privity. As I stated earlier, they're separate and distinct entities with different interests. One is a tenant, one is an owner, and they have different interests in the property. As stated, this is part of my third argument, based on the Trace
about
case,
the scope of the remand.
the lease and the tenant retaining the benefits of the improvements of the land. That demonstrates a distinct interest in the property from Holdings, the tenant, and Realty, the owner. As any improvements to the property are in the possession of the tenant and are for their interest, the owner does not retain control of that, so therefore there are different interests in the property. And as I've stated, based on the artisan contract case, in that case there was a knowing and willful misrepresentation as just to the amount owed, but at least in that case they got the correct party, that this party, the defendant in that case, or the owner of the property, actually owed the money under a contract. But in this case, Holdings, there's no dispute that Holdings did not owe them a dime. Holdings did not have a contract with them, and yet they were named on a lien. To this day, they're still named on the lien, and that has impeded their ability to obtain financing. And for example,
So whether it was 2.2 or 1.6, one argument is not a party. The second one is the willful and intentional. And aren't you bound, since it wasn't appealed and in fact it was agreed by the arbitrator's factual findings, that didn't say willful and intentional. In fact, it was just they believed they were entitled to 2.2 and the arbitrator said, you're entitled to 1.6, this other $500,000 of monies that were not expended, you're not entitled to.
the willful and intentional portion pertains to naming realty on the statement of account and on the notice of the contract, because it's undisputed, CSM never had a contract with them. And to add on to the significance of that, if the lien only attached to the tenant hold interest of the contract, the tenant could surrender the premises and the lien could be absolved from the property. By falsely naming that realty was a party to the contract, they're prevented from doing so, and that also goes towards my first argument on the slander of title claim, that is a separate legal and factual basis, which is why I respectfully submit that the Superior Court erred in allowing CSM's motion to dismiss the counterclaim brought by realty for slander of title. As Judge Hodge states in his ruling, he states that the factual claims are the same and that those claims were already addressed at arbitration, but that is an error of law because the factual basis for realty's slander of title claim is that they were falsely named on the statement of account and notice of the contract, and as title holder of the property, that has impacted their ability to obtain financing on the property, and they've been subject to this lien for 5 or so years now.
Does your argument hold water if we have privity?
Yes, even
What
if there...
survives if there's privity between H and R?
Yeah, even if there is privity, which I'll respectfully submit there is not, the argument still holds water, Your Honor, because the law requires that the interest of the party in privity with the party that attended the arbitration be represented, and that could not have been represented at arbitration because Holdings did not bring a slander of title claim. That claim was only brought by realty, and the factual basis of that claim is that realty was falsely named on the statement of account and the notice of the contract. That was not an issue at the arbitration. The issue at the arbitration was whether the contract that did have holdings on it was the product of fraudulent inducement.
Yeah, it's not claim preclusion, and sorry to interrupt you, it's issue preclusion. So if there's privity, right, and there was a determination that H had a contract with CSM, and there's already a determination of privity, then in order to prove slander of title, a necessary element would be missing, correct?
No, Your Honor. The necessary element for the slander of the realty is the party that holds title to the property.
Right.
And that issue, whether there was any basis to name them on the lien,
recording.
to name them on the statement of the account or on the notice of contract, that impacts their ownership interest in the property, and that was never addressed at arbitration.
Right. But my point being, and we're going around in a circle a little bit, but if there's privity between F and H, excuse me, R and H, my consonants are not correct, then how do you say, even under de novo review, that there's something that still survives? What's your best case? What's your best facts to show that there's no privity? What's your best case to say that even if privity, you still get to pursue these counterclaims?
Number one is even if there is privity, the interest of the party that is in privity with the party that attends the arbitration has to be represented in the arbitration in order for preclusion to apply. Here, that couldn't have happened because Holdings did not bring a slander of title claim against CSM. So the factual and legal basis for the slander of title counterclaim is distinct. So even if there was privity, that interest was not represented at arbitration because it was not at issue. So the ruling of the arbitration can't be binding.
Are you saying that it couldn't have been done? as opposed to it was not done.
Or it was not done. But I would
But could
just submit that
could it have been done?
I would suggest it could not have been because it was not an issue before the arbitrator.
What could it have been?
Could they have brought it in the arbitrator? Yes. I was not counsel at the time, so I can't speak to why
That's how
that
issue
was not
preclusion
done.
works, though. It's claims that are brought or could have been brought.
But also, Your Honor, the CSM moved to compel Bellfleur Realty to arbitration, and the judge denied that motion and held that because Realty was not a party to the contract, they are not compelled to arbitrate. So I believe it is inequitable to then dismiss their counterclaim that has a separate legal and factual basis because, they could have attended arbitration even though the court ruled they did not need to attend. I believe it's a violation of their due process and their right to be heard in court.
You started with the mechanics lien issue, and you would agree that General Law, Chapter 254, Section 50A requires, is mandatory language requiring the filing of a verified complaint to discharge the lien, correct?
Yes.
And there was no verified complaint filed here, is that correct?
No, there was not, but I'll submit nothing in the statute precludes, strips the Superior Court of power to dissolve a lien via motion, and that was done in the artisan contract case that's cited in my brief. It was a motion to dissolve the lien, and the Superior had the power to dissolve the lien.
So I was just about to ask you, is there any case law interpreting that mandatory? Did that case actually address the mandatory language of General Law, Section 15A, or that was just the result that was reached in that particular case?
I believe it was just the result, Your Honor.
Are there any cases directly addressing that question?
Not that I'm aware of, but I would just submit that that puts form over substance, and I think there's a policy in the Commonwealth to resolve a case on its merits, and here the merits are clear. It was a knowing and willing misrepresentation that that Realty was a party to the contract and that Realty owed CSM any money at all. And as stated in my brief, the statute requires exact compliance, and by
But
stating
then why
that,
do you think the legislature included that mandatory language in the statute if it can just be ignored and judges can say, well, we just want to get to the merits anyway?
well,
I certainly understand your argument, but we have to look at this carefully, so.
well, I would submit that one issue that kind of goes around the verified claim is this required fact-finding, and there was an active lawsuit already pursued when this motion was brought. I can understand if initially when the lien is filed, instead of having to go through the time and expense of a court case to file a verified complaint initially, but at this case there was already an arbitration award and it was in litigation, so the most efficient means was to go through the Superior Court via motion.
Okay.
And then finally, just to address my the final point in my brief, there was never a determination as to the scope of the lien. Under the Trace Construction case that's cited in my brief, in order for the lien to apply to the ownership interest of the property versus the leasehold interest of the property, there needs to be consent by the owner, and that was never addressed at arbitration or by the Superior Court. So I think at a minimum, I would respectfully submit that at a minimum, it be remanded to the Superior Court for a determination as to the scope of the lien. And as stated in my brief, the lease indicates that any improvements to the property are to the benefit of the tenant, and the tenant retains possession of that, which is pertains to the point that the scope of the lien would only apply to the tenant versus the ownership interest. And as I said, that was never addressed by the Superior Court. So I'd at a minimum ask that it be remanded in order for that determination.
Well said.
Thank you.
Thank you.
Mr. Mahoney.
Good morning, Your Honor. May it please the Court, Michael Mahoney for CSM, the appellee. Your Honor, I'd like to just start on that last point with regard to the lease. The lease is not effective. The lease is dated August 18th, 2021, I believe, or 22. It was created 6 days before BFR allegedly transferred the property. Well, we know they transferred the property for no consideration whatsoever. So at the time the lease was created, BFR did not own the property. Moreover, the argument that the lease was not affected and there's only a tenancy ownership that the lien should apply to is also inaccurate, because the lease says within itself, if we were to believe its writing, that the purpose of the lease is for a marijuana cultivation facility. So that is also in support of our argument that there was consent and that BFH was acting for or on behalf of BFR. And then finally, with regard to the lease, we have Mr. Rolandi on both sides of the lease, as the landlord, even though he didn't own the property at the time, and also as the tenant, which is BFH. So it's clear to me, and I think it should be clear to the court, that Judge Hodges' findings with regard to privity can't be appealed. The appellant agreed to the arbitration findings going into, being marked as a finding in result, for CFM. And we marked that as an exhibit in the supplemental appendix number 7. So they are bound by those findings. And with regard to the overstatement of the lien, there was absolutely no finding by Mr. McDonough. In fact, he found that CSM mitigated the amount of the lease by reducing the amount and providing the appellant with credits for the purchases that it made for the construction that it never got to. It had purchased various amounts of equipment. It then sold them and recouped the money on other jobs. So to suggest that we willfully inflated the price of the lien is, it's just not borne out by the record.
Let me interrupt for a moment. It seems to me that BFR's argument, their claim is, despite arbitration between H and CSM that resolved some issues that perhaps they disagree with, but it resolved whether a contract existed. R says, my claim is different, and I never had an opportunity to be heard about this, right? Because Judge Callan was clear. The arbitration is between these two about the existence of a contract. I wasn't a party to the arbitration, so the judge can look at it for what it's worth. How does that waive his argument of privity and bind him to a finding that he was never a party when his claim is, my argument is different than H's. My argument is that you put a lien on something I never signed a contract with. I had nothing to do with it. And that was intentional to include me in it, right?
That's correct, Your Honor.
Okay, so tell me why he's stuck with the arbitration when he wasn't even invited to that party.
Because Judge Hodge found that the transfer of the property was the furthest thing from a good faith transfer, number one, in an effort to avoid this debt. And number two, Judge Hodge also found that there was privity between BFH and BFR. And consistent with what Judge Callan found with regard to the testimony of the individuals when they accused CSM of fraud in the inducement, he found them not credible. There was no affidavit filed in accordance with 15. We don't have any testimony from either of the principals at BFR or BFH suggesting that they did not consent, that they were not BFR's proxy, they were not acting for or behalf of BFR, et cetera. What we do have is 7 instances of consent and or evidence that they were acting for or behalf. And I'll just go through them and cite them to the record appendix if we may. We have, first of all, the AIA contract, where BFH represents that it's the owner and it has the authority to contract with my client. Secondly, we have the representation to the Cannabis Control Commission, where Mr. Romulus assured the Cannabis Control Commission in 2020, which is long prior to the execution of the contract, that he had control over the property for security purposes, making no distinction between BFR and BFH. Thirdly, we have the letter to the town by Mr. Romulus indicating that he, as the representative of the owner, BFR, has granted BFH permission to do this construction. Fourthly, we have Foresight Engineering's, who's the engineer on behalf of the owner and the business there, as they represent, and that's Supplemental Record Appendix 22, that they are applying for permits on behalf of both the owner and the tenant. Fifth and sixth, we have Mr. Cardarelli's testimony before Judge Callan, where he indicated that they were trying to get a loan secured for BFR, and they wanted BFR to be named on the contract. Sixth, we have Mr. Cardarelli testifying again before Judge Cardarelli, and by the way, these are supplemental record appendix 18 and 20, that when they tried to work this out before suit was filed, and CSM suggested an amendment to the contract, that Mr. Cardarelli was upset because he thought that BFR should be named in the contract, not BFH. And then lastly, as an addition of authority to act on or behalf of the owner, we have the lease. Again, it was executed 6 days prior to the actual transfer of the deed for no consideration, which Judge Hodge found was not a good faith transaction. We have the use of the premises, which is specifically outlined in the lease, and by the way, that's Record Appendix 356. And then, as further evidence that the lease was a fiction, as well as the distinction between these two companies, we have a rent charge of $250,000 per month. Now, this case is about a defendant who could not pay my client for the site work that they did to develop this property. So to consider that they had the ability to pay $250,000 a month is ridiculous. And moreover, there's no evidence in the record, there's no evidence in there's no evidence in opposition to the motion to dismiss that supports that this was a valid lease in terms of rent payments. So the lease, as with the distinction between BFR and BFH, is a contrivance. Now, should the lien have said with the consent of or for or behalf? Probably, it should have said that. But at the time that the lien was drafted, the complaint specifically says, if I may read from it, and by the way, it's Record Appendix 12. On or about May 1st, 2021, CSM entered a written contract with Belfleur Holdings, LLC, which at the time of the contract was the owner of the real property. There's no dispute about that, because the contract itself also contains the provision on the very first page of it that the contract applies to work done prior to the execution, which was December 6th or 8th of 22, and following the execution. The complaint goes on to say that on August 24, we point out the transfer, Belfleur Holdings, LLC conveyed its interest in the real property for no consideration. I attached that as an exhibit to the complaint. Since August 24, 2021, Belfleur Holdings, LLC was acting on or behalf with the consent of the owner for the whole or part of the erection, alteration, repair, removal, etc. So we learned of the transfer when we went to file the lien. That's why Belfleur Realty was included, because we knew that they were in privity, and clearly Judge Hodge found that they were in privity as well, and that it was just a fiction created in an effort to avoid the debt. Judge Hodge also
I'm sorry to interrupt you, but before you run out of time, I'm glad you mentioned the lien. You make the argument that they failed to follow the statutory mandatory language in 254, 15A for discharge of a mechanics lien because they failed to file a verified complaint.
Or an affidavit.
Does that, well, that's my question. Your brother argues that since there was an ongoing existing case, it wouldn't make sense to file a verified complaint in that situation. But your argument, I gather, then is, well, if there's an ongoing case, they at least have to file a verified affidavit?
Yeah, well, an affidavit's verified, self-authenticating.
By definition.
Exactly, Your Honor. I would say yes, because if you look at the statute doesn't want the lien dissolved based on argument of counsel. It wants the lien dissolved based upon a willful or intentional excessive amount that was initially applied to the lien.
Where's the requirement of an affidavit in 254?
There is no requirement of an affidavit. There's a requirement of a verified complaint, which we don't even have a subsequent complaint being filed here. But my point is,
they may apply to the Superior Court for an order of a ruling summarily discharging of record the alleged lien or notice as the case may be. And it says the application shall be made upon a verified complaint accompanied by other written proof of the facts upon which the application is made. So when you have an existing case, it doesn't necessarily make sense that you would file another verified complaint.
if we're going to look at the statute,
You're suggesting that we should read into that there should be some form of a verification.
exactly, Your Honor, because
Are there any cases stating such?
as my brother said, there aren't any cases like that. We're taking the position that I think my argument would be substantially weaker if they had filed an affidavit. But if we look at the facts of this case, they were incapable of filing an affidavit because of the 7 instances that I cited of consent, of the ability to act for or behalf of of BFR. And
No, I understand you've answered I understand your argument, and you've answered my question. So,
thank you.
Thank you.
So, Your Honor, we think that Judge Hodge got this specifically correct. He said that BFR had every opportunity to be represented capably and articulately, particularly in the motion to dismiss stage. What the appellant wants the court to do is just to completely disregard the findings of the arbitrator, and there's no legal ability for that to happen because they consented to the order of the arbitrator being entered into this case as a judgment. They never appealed that in a timely manner, and now they want the court to re-examine those facts. And the TLT case is specifically clear. Even if the judge got the facts wrong, they have no recourse there. Having said that, Hodge took that decision and compared the allegations made by the BF entities as they are described in the counterclaim. So they're even blended at that point. And he compared them, and he essentially said that the slander of title claim is similar to or identical to the breach of contract claim. Moreover, if you take that analysis one step further, in order to have a slander of title claim, you have to prove that it was a willful misrepresentation of fact that adversely affected the property. We don't have any evidence in here to support counsel's allegation that they haven't been able to obtain loans. There's been no testimony with regard to that. But putting that aside, the arbitrator and Judge Hodge found that there was a valid contract with BFH, found that the lien with regard to BFH was valid, and therefore there can be no damage to the property because even if BFR had not been named on the lien itself, we still would have a valid and existing lien with regard to BFH's interest.
I'm not discounting some of your arguments, but it seems to me difficult to understand, at least procedurally. R is not a party to the arbitration. Judge Callan made that clear. This is an issue between H and CSM. An arbitrator decides and makes a decision, and you're suggesting that R could jump in to somehow argue that this shouldn't appeal this decision or stipulate when it had nothing to do with R then, and that arbitrator's award is agreed upon and the Superior Court judge endorses it, correct?
No. What I'm suggesting is that at the time of the motion to dismiss, R had its opportunity. The facts were looked at in a light most favorable to R. Judge Hodge found that there was privity, found that the claims against R were exactly the same as the claims against BFH, and it had its opportunity at that time to prove that it had a valid and existing claim to go forward against CSM. Like we say in the brief, it would have been a fool's errand to permit discovery on that issue because there wouldn't have been any different facts against BFR. They were exactly the same people.
So once privity is found by the judge,
That's correct.
it closes off.
That's correct. Once privity is found by the judge, the issue is precluded, and add to that the fact that they did not appeal the arbitration within the appropriate time under the statute. I see my time has expired, and I thank the court for its attention.
Thank you both. We'll take it under advisement. Thanks.
Good job.
The next case is 25P260 Morse Brothers Incorporated versus Town of Halifax Select Board. Also, I'd like to acknowledge the amicus brief that was filed in this case by the Pioneer New England Legal Foundation. Mr. Huxham.
May it please the court, good morning. My name is John Huxham. I represent the town of Halifax and its Board of Selectmen. We are asking you to overturn the Superior Court's decision and also to uphold the soil removal permit and the soil removal bylaw that are at issue in this case. And we say that the Superior Court made several significant errors in this case. The first one was that it erroneously found that the soil removal bylaw requires a special permit. The soil removal bylaw does not require a special permit. It's a non-zoning general earth removal bylaw enacted pursuant to Chapter 40, Section 21, Paragraph 17.
But you required them to have a permit, though.
We did require them to get a permit.
I'm not sure if it deprives them of the agricultural exemption, what difference does it make what we call it?
It's a very good question, Your Honor.
I worked hard on that one.
First of all, our position is that one of the other fundamental errors that the court made was finding that Chapter 48, Section 3 applied here. By its clear terms, it does not apply. It only applies to zoning bylaws or ordinances, and our position is that the clear...
Well, the bylaw by its terms doesn't apply here either because it limits it to 1,000 cubic yards, right?
Well, the 1,000 cubic yards only relates to when a permit is required. It does not say the maximum that can be permitted. So there's an exemption for agricultural uses if it's less than 1,000 cubic yards. No application is required. But above that, permits for agricultural uses can be granted.
They can't be repugnant to existing law.
No, they cannot.
And why not the Dover Amendment or the Zoning Act, whatever you want to call it, has an agricultural exemption?
Well, again, our position is that clearly by its unambiguous terms only applies to a zoning bylaw.
So the zoning bylaw can trump a statute enacted by the legislature?
It really doesn't, Your Honor, because we're talking about two extremely fundamentally different animals, really.
What's really going on here? I mean, they've been running this business for 45 years, uninterrupted, and 2 years ago, out of thin air, as far as I can tell on this record, you decided they need to have a permit. That's going to cost them a lot of money and affect their business. Why?
Your Honor, this was something that was done in good faith by the town. It's perceived that there are issues out there with the earth removal operation, and of course, there's no. The town isn't stopped from enforcing its bylaws simply because they weren't enforced in the past. That's pretty fundamental land use law. But we think it's very important that there's a fundamental difference between this soil removal bylaw and permit and a special permit. They're really totally different. I mean, not too long ago, in fact, very recently, this court in the Troy Currents versus AD Makepeace case said that the primary purpose of an earth removal bylaw is to protect the environment. Under the Zoning Act, the purpose of a special permit is to, in Section 9 of Chapter 40A, is to determine where specific types of uses will be allowed. So those are two totally different things. And the other aspects of the soil removal bylaw that are very important are that first, there are waiver provisions. It's extremely broad in its waiver provisions. So the Board of Selectmen...
I think your brother points out in its brief that two waiver provisions don't apply here.
We disagree with that, Your Honor. The waiver provisions allow the Board of Selectmen to completely waive all procedures and to completely waive all conditions. So there's that. But the other thing is, I think we have to carefully and accurately read the soil removal bylaw, because under the soil removal bylaw, there are only two types of of projects that are prohibited. The bylaw prohibits a project that will endanger the general health or safety or constitute a nuisance, and it prohibits a project that will result in detriment to the normal use of adjacent property by reason of noise, dust, or vibration. Those are the only two.
Here, the exemptions in the bylaw are not in excess of 1,000 cubic yards, meeting certain requirements, so that doesn't apply. On land owned or operated by the town, that doesn't apply. Incidental or reasonably required for legal operation of a cemetery, that doesn't apply.
So again, this is talking about when a permit application is required or when it's not required.
You told me that the town can waive all the requirements, and they're enumerated in what can be waived, and it doesn't seem to fit. So help me out. Where does this all-encompassing waiver power come from?
Again, Your Honor, I think the distinction between having to apply for a permit and obtain a permit and when an earth removal operation can be prohibited are two different things. And again, obviously, we're arguing that 40A Section 3 doesn't apply. But even if it did, this would comply with 40A Section 3. Because under 40A Section 3, it only forbids prohibition, requiring a special permit, or unreasonable regulation. It doesn't say no, you can't regulate.
Let's go to unreasonable regulation. All the conditions that were placed on them that you say in your brief aren't regulations. How is requiring the trucks not to drive more than 10 miles an hour reasonable?
So that category of the conditions in the permit are in response to the concerns of the neighbors.
The board didn't make any findings that specifically tied to the creation of these conditions. You had citizen complaints, but they're not tied to anything. The board doesn't tie them to anything. Citizen A complained about this, therefore the trucks can only drive 10 miles an hour. The board didn't do that.
That is correct in the permit. It doesn't say that, but the record clearly contains.
Clearly is a tough word in the appellate world. If it was clear, we probably wouldn't be here.
The town's position is that in the public hearing, residents in the neighborhood expressed this concern.
I'm with you, but the board didn't make any finding tying any of those concerns to one of these conditions. So, which makes it sound like it's arbitrary.
It's not in the permit, but we don't think it's arbitrary because it's clearly in the record.
So they limit them to only 25 trips per day.
Yes, Your Honor.
Yeah, so it might be tough to do 25 trips, even 25 trips a day, if you can only drive 10 miles an hour on Linden Street.
Well, the residents were concerned about the safety of their children, and that's where that came from. But I think we should look at some of the other conditions that are in the permit, because if we're saying that, they can't have this permit, one of the other conditions, which I think directly relates to the Currents versus AD Makepeace decision, is that there has to be test wells and testing to determine the groundwater elevation, and that the earth removal operation can't be within 4 feet of the groundwater elevation. And it's in the record that there are 2 of the town's drinking water wells are in this area, and that it's in the zone 2 for their drinking water. So those conditions are directly related to what this court has said is the purpose.
How long has that drinking well existed?
I don't know the answer, but it's been, I believe, long.
Probably for 45 years at least.
It's been there for a long time.
Has there been a problem? Was there an issue related to the well because of Morse Brothers cranberry bog?
They're trying to prevent
an issue. You just told me it's never been a problem.
So they don't want to wait till it becomes a problem. They want to.
Was there any citizen complaint that linked the truck travel on the street to school bus operations? One of the conditions is that they can't truck during operation of school bus hours.
It's related to when the children are going to be around.
Was there a
safety of the children.
Was there a complaint that the trucks interrupted the operation of school buses?
No, Your Honor.
Oh,
It
so
was-
we're back to arbitrary again.
Again, in the record, there are these first-hand accounts of the residents in the neighborhood based on their concern for the safety of their children, of the Morse Brothers trucks coming in and out, and they're concerned about the safety of their children.
So I had two questions for you, and you've answered one of them, which is, are you familiar with the Currents case that was just issued? I believe Justice Englander authored that case as well. My second question, and you may have already answered this, I was under the impression, perhaps incorrectly, that this case hinged in part on the interplay between the Dover Amendment and General Law, Chapter 40, Section 21, Paragraph 17. You're arguing now that you make the argument that the Dover Amendment doesn't even apply here. Assume it does. So if it does, how do we analyze the interplay between that statute and the earth removal statute? And are there any cases providing us guidance on that?
If we assume that it does, the town's position is that we comply with it. Because as I've mentioned, 48 Section 3 only says that you can't, it forbids prohibition or unreasonably regulating or requiring a special permit. The way I read that plain language is it preserves reasonable regulation. And I believe we cited some cases in our brief that talk about when uses exempt under 48 Section 3, the Dover Amendment, can be subjected to reasonable regulation. I mean, similar to like site plan review, which we've mentioned in our brief. Not prohibition, but reasonable regulation. And to say that you can't even require anyone to apply for a permit goes beyond reasonable regulation. It means you can't regulate it at all. It would be like removing the word unreasonable from 48 Section 3.
So I lied to you. Now I have a third question, which is, what makes a permit a special permit within the meaning of the Dover Amendment as opposed to a non-zoning permit outside the scope of the Dover Amendment?
Well, I think that's a very important question because a special permit, it's not just some term that's thrown out there. It is a specific thing. In the Zoning Act, Mass General Law, Chapter 48, Section 9, is all about special permits. And it says there that what a special permit is, it is to determine what specific kinds of uses and where they're going to be allowed. I mean, an example you could use, which is pretty common in towns, is let's say you're going to have a restaurant or a coffee shop or something that's going to have a drive-through. Lots of times they require special permits for those because they want to determine where that's going to be able to be. That has nothing to do with an earth removal permit. It's fundamentally different. Earth removal permits are to prevent the negative effects of earth removal operations, and including to prevent environmental damage, as this court has said. So it's a specific term that's used in 48 Section 3. I mean, there's also the reference to zoning bylaw or ordinance, which this is not a zoning bylaw or ordinance. And I'll say, just in passing, and I've addressed this in our brief, I believe that the cases that the Superior Court cited to kind of take that out to say, yeah, but it does apply to this too, they really don't apply here at all. They're about denial of licenses. Again, we didn't deny anything. We allowed them. And I think that's a very important point. They came and we granted them permission to do what they wanted to do. We did not deny it. We granted it with reasonable, what we feel are very reasonable conditions. So just to summarize, the reasons that we ask you to overturn the decision are, one, the erroneous finding that a special permit was required, the erroneous finding that Chapter 48, Section 3 applied here, and the erroneous finding that the bylaw is invalid on its face in regard to agricultural uses. Because again, there's the special permit requirement reference, which is inaccurate. And again, in our view is that 48 Section 3 doesn't even apply.
Thank you.
Thank you very much.
Mr. Rosenberg.
Thank you. Good morning. May it please the court. My name is Nick Rosenberg, representing the appellee, Morse Brothers, Inc. As you know, it's undisputed in the record below that the movement of sand that's at issue here is agriculture. Moving sand on bogs, and cranberry bog stimulates root growth. It helps protect the soil from pests and weeds. It's vital to water flow and retention. That movement of sand is the cultivation of cranberries. It's also undisputed that the town of Halifax told Morse Brothers, you can't do that cranberry cultivation unless and until you come to the town, get our permission to go do that with conditions. And as we know, and your honors already identified, the town did issue a permit with conditions limiting the volume that they could move, the 25 trips, the timing, the days. They imposed additional liability, supposedly, and conditions on the truck drivers and what they could do on public ways.
So can you rescue us from the tyranny of labels and explain why this is a special permit and not just a permit?
Right. So it would be weird to have a town, let me back up. It's undisputed, I believe in the Glacier Beard cases and others, that a town can regulate earth removal either through Chapter 40, Section 21, Paragraph 17, or it can do it under 40A as a zoning ordinance. It can do an ordinance and put it into its zoning act, and under 40A, as you know, there's some more procedural stuff you have to do to get that approved, but they can do it under zoning, or they can do it under 40. It would be weird if they could pass a earth removal bylaw and put it in their zoning bylaws and say, and I think we all agree that they then could not require a permit. But if they take it out of that and do it under Chapter 40, now we can require a permit for a farm that wants to engage in farming. That would be strange. The second point I would make is that just as a matter of basic statutory construction. So Chapter 40, Section 21, the Paragraph 17 that we're talking about came into effect in 1950. That says that towns can generally make laws to regulate or prohibit earth removal. As you noted early on, Justice Mead, that also says that those restrictions are subservient to other laws. They can't be repugnant to other law. In 1975, the major amendments to what we now know as the Modern Zoning Act added the language to the Dover Amendment in Section 3, protecting farms from any sort of permitting scheme. Essentially saying we don't, again, this embodies Article 97 of the Constitution. It embodies the right to farm, public policy aspects. It embodies the purpose of ensuring towns can't locally control when farmers can farm, whether the permit's granted or not. The legislature said in 40A, Section 3, if people are farming, you can't tell them they have to stop farming, come to the town and get approval to go do that. Whether or not that's granted, whether or not the conditions are reasonable, you can't do that. And as we know from RACO and lines of cases following RACO, like the Land Court and Larison, said you can't subvert 48 Section 3 by just doing it under Chapter 40. And yes, there are cases that refer to licensing statutes, but it's the same principle. Again, with RACO and the trailer park, Chapter 40A, Zoning Act says you have grandfather protection for 3 years. The town says, but if we do it under a licensing scheme, we can limit the number of trailers they have in the trailer park. The courts, SJC said, no, you can't do that. There's a general purpose. And so back to your point, Justice Mead, I don't know that it is technically a special permit. Special permit is not defined. But the purpose obviously is...
Your brother says it's defined in 48 Section 9. Is that incorrect?
That's incorrect. 48 Section 9 talks about when special permits, how special permits are used, how they're implemented.
There are definitions in Section 9, but special permit's not one of them, I don't think.
I don't believe there is.
I'll double check that.
Yeah, I wouldn't say I'm 100% sure, but I don't believe there is, Your Honor. But again, the special permit scheme in 40A is not just sort of a technicality of a permitting scheme. The Dover Amendment embodies a very important purpose. As I said, farmers should not be stopped from doing what they're doing to have to go to the town to get a permit. There's a larger public policy that farms are subject to state regulation, federal regulation. And in fact, if you look at Halifax's own Chapter 137, which I believe is at Appendix 351, that's the town's own right to farm law. And that helps explain the purpose of these protections for farming. In fact, in Chapter 137-3 of Halifax's own right to farm provision and bylaw, Appendix 352, the right to farm is hereby recognized to exist within the town of Halifax. The above described agricultural activities may occur on holidays, weekdays, and weekends, by night and by day, and shall include the attendant noise, odors, dust, fumes, normally accepted agricultural practices. The town, like the Commonwealth, recognizes there are local concerns about farming, but we don't want that to enable towns we don't want towns to have the ability to stop farming from happening.
Well, is your argument then that the Dover Amendment trumps any application of Chapter 40, Section 21, Sub 17, if it so much as touches on any agricultural use, or any use, anything incidental to that?
No, I think the case law is fairly clear that it has to be agriculture. So, we look at some cases where there are things that are, for example, the Cumberland case and the Prime case. Those fall into a different part of actual Section 3 that refers to buildings. So in Cumberland, the proponent wanted to build a new barn. And the court said, well, under Chapter 48, Section 3, agriculture, you can't require a special permit. But then there's a separate provision for buildings and structures. And then Prime, the same thing, it was a farm stand. So that's addressed separately. In fact, what's interesting in those, they say that in Cumberland and Prime, which I think my brother relied on to some extent to suggest, to support their argument, what Cumberland and Prime are saying is that a new structure is not protected in 48 Section 3 the way an existing structure is. And in those cases, the proponent was trying to build a new barn or a new farm stand, and therefore they're not entitled to those protections of not being subject to a special permit. However, because it touches on agriculture, you still can't unreasonably regulate them because it is part and parcel of agriculture. And the courts say, there's very little that you do on a farm that's not part of farming, and the business of farming includes that farm stand.
Can I'm getting more confused. So help me understand for a moment. Is your argument because it's undisputed that this is agriculture, Halifax cannot require a special permit? End of story.
Correct. They cannot require Morse Brothers to do farming.
Right.
To do farming.
Right.
To come to the town and say, well, actually I had that backwards because they didn't come to the town. Town said, stop what you're doing.
Apply for a
permit. You can't cultivate your cranberries.
Permitting is not allowed because it's undisputed that this is a cranberry, the agricultural use of cranberry farm.
Yes, Your Honor.
Right? Okay. So this analysis about a particular bylaw being repugnant to the overriding purpose of legislative action doesn't even need to be addressed. Right? So, in other words, some of the argument was, well, wait a minute, the town of Halifax's bylaw can live harmoniously with also allowing earth removal. We're just making sure that our town is protected and that the earth and soil is being done in a way, and we're working harmoniously. The other way of analyzing it is it repugnant to?
Right.
We don't get to that analysis if we accept your first proposition that as a result of this entity clearly meeting the definition of a farmer, you can never permit.
I agree, Your Honor, and I appreciate that. To be fair, I do think because my brother and the town has argued, well, we have it in a non-zoning bylaw, we have to address that and say, well, that non-zoning bylaw is subject to 48 Section 3. So I think the answer is yes, but I think we do have to at least acknowledge that there's an argument this is taken out of the zoning context, and our response is it doesn't matter that you just moved it over to a non-zoning bylaw. And I would point out, I know there's been a lot of discussion about the environment, protection of the environment and regulation. There is no suggestion that these farms are completely unregulated. As you know, they've been farming for 40-odd years doing this, and they've been regulated. And we point in the appendix in our papers to the town of Carver, and their bylaw is in the record. The town of Carver says, we're going to do earth removal. We have a bylaw that says you have to get a permit, and we have exemptions, just like Your Honor, Justice Meade was looking at the exemptions earlier. Their exemption is farming and agriculture is exempted. And they even go into more detail and say specifically cranberry farming, because obviously cranberries are big in Carver, and they say cranberry farming is exempted. But here's what's interesting. They then say, but all cranberry farming shall be done in accordance with best practices. So they regulate. Now, one farm might argue that that's either reasonable or unreasonable as applied to the farm. But Carver regulates cranberry farming to some extent, because in their bylaw they say all cranberry farming must be done in accordance with best industry practices. But you don't have to come get a permit. We can't stop you from doing what you're doing until you have to come before the town to
So
farm.
let's go back to the present case. Same set of facts, but assume that there was evidence in the record before the board that the Morse Brothers trucks go by at the speed limit, but 55 miles per hour. They spill sand consistently, which creates dust by bus stops, which harms children, and the sand spills and it affects the environment, and it deteriorates the roads.
Right.
Nothing they can do about that?
Well, sure there is. Well, one, you could have bylaws that aren't permitting bylaws that say what you can and can't do if it complies with the authority given by the legislature as to what towns can regulate.
Under the existing structure, under the existing bylaws,
Right.
what can they do in the situation I just gave you?
They can use all the other tools and laws available. If there are traffic tickets for speeding,
Let's say they're not speeding, but it's still creating.
I assume that there are laws, whether state law or local, that says you can't, if you're liable, if you litter, if you dump stuff on the road, you're liable. There's common law, there's nuisances, there's a host of other things that would address this. But trying to package it into a permit, it just isn't allowed under 40A. And as you know, there's a separate argument that the town just doesn't have authority to regulate traffic. I think in the Beard, the Glacier, and the one other case we cite, it's fairly clear that the town just doesn't have that authority.
What's your best case for the proposition that in the context of this case, this constitutes a special permit or a permit within the meaning of the statute?
I think if you look at RACO, obviously it's just SJC. I'm not talking about earth removal, but
RACO, though, to me is materially distinguishable, so what else do you have?
I think Larison, which is a land court case, so it's not authoritative, but I think the land court, the analysis is appropriate in Larison. And I think as I went back, I mentioned Cumberland and Prime together. Prime sort of refers and analyzes Cumberland. Slightly different because there we're in the zoning world, but as I said, the point there is that distinction that if it says you can't require a permit, you can't require a permit. If it's a new building, it doesn't say you can't require a permit, so you can regulate it, but if it's an old building, you can't do it. So again, slightly different, but emphasizes that it means what it says. Just saying, oh, but it's reasonable regulation doesn't mean you can get away with requiring a permit. I'm happy to answer other questions or address the other issues as Your Honors like. You have an issue, obviously, we also challenge that the fee that was imposed is unlawful tax. I think our brief addresses that fairly clearly, that to be a legitimate fee, it has to actually reimburse the town for something. It has to reimburse the town for a government service, and it can't be optional.
The judge didn't reach that, though, right?
No, he said it was arbitrary because when you look at the record from the town meeting, the board was kind of grasping, how do we charge these guys money? They said, well, we think it's 25 cents, but we want to double it. And then what's really interesting is they get into, well, can we charge them for the potholes? And someone says, well, we haven't actually incurred any costs. Or, oh, they have to pay for that anyway under the permit. It's a requirement, so that's not a charge. Or what about the trap? They sort of grasping for things to charge them for, and every time said, well, we can't really do it. And I said, well, let's double it and charge them 50 cents a cubic yard. And just the mere fact that it's 50 cents a cubic yard, it's based on the volume of sand. that Morse is moving its own sand on its own bogs has absolutely no connection to any government service being provided or legitimate reimbursement. So I think you're correct. I think Judge Glennie looked at that and said it's just arbitrary and didn't get to the unlawful tax issue. Thank you very much for your time.
Thank you. Thank you both. We'll take it under advisement. Do you want to do the divorce? Sure. Why don't you just do that? It's only one credit. All right. The next case is 24P301 JR versus KR. This case is partially impounded, so please refer to the parties by the initials. Ms. Mansfield.
Good morning, Your Honors, and may it please the Court. My name is Katie Mansfield, and I am the 303 certified to appear here today on behalf of ex-wife appellant KR. I'm here with my supervising attorney, Jacob Chin, but I will be the one doing today's argument. I'm here to argue three main issues. First, that the trial court erred in not granting alimony. Second, that the trial court miscalculated JR's income for the purpose of alimony and child support. And third, that the trial court made a clear error in its valuation of the marital estate and its decision to present KR with only half of it. On the issue of alimony, the trial judge made two main mistakes. The court blurred the distinction between alimony and property division and made a clear error in weighing the required factors for alimony. The SJC has stated that it is important that courts do not blur the distinction between alimony and property division. This is because property division and alimony serve two different policy goals. Property division exists to recognize the joint contribution of the spouses to the marital estate, while alimony is based on the duty and ability of one spouse to support the other spouse's maintenance of the marital lifestyle. When these two are conflated, as the trial judge has done in this case, it can create drastic inequities. The trial court found that KR needed support to maintain her lifestyle, and based on the parties' large gap in station, calculated an alimony award. But then it said that KR's need could be taken care of through the division of the marital estate. This clearly blurs the distinction between the two. And simply supplanting the proper award of alimony with property division fails to meet KR's need. And I'd like to I think the case that's most on point for this is Grubert, where the appeals court reverses the trial court's award of a 50-50 division of marital estate and $400 a week in alimony based on running the numbers and seeing that under that award, the wife is still burdened by debts week over week and barely able to meet her needs. And that's exactly what's happening here. So the trial judge found that KR and JR had reasonably similar expenses, but KR's income, weekly income, is about a fourth of what JR's weekly income is. And so based on that, there should have been an alimony award of about $324 a week. Meanwhile, however, the trial judge said that that could be offset by the property division. But the property division math comes out to only about $136 a week. And so that barely closes the gap between these parties. And KR has been deprived of over half of what she would have received under traditional alimony principles.
Judge also entered a finding that neither party entered any evidence regarding the tax implications of an alimony award. And I think the record supports that finding, in that without expert testimony on that, the judge can't make that calculation. Isn't that a problem for you? I think the answer to that is yes, but go ahead.
There are tax implications, but the trial court also has multiple levers it could pull. And so if it didn't want to do alimony, then it could have.
It's not that he didn't want to, it's that he didn't have the information before him to do other than he did. He did not label this as really a decision. He really characterized it as, based on the record before me, I don't have credible evidence to do otherwise.
I believe from the corrected findings that the judge's discussion of the alimony award, though, is more about the parties' incomes, expenses, liabilities, and the division of the marital estate. And so taking that as the judge's reasoning, then it is clear that the judge blurred the distinction between the two.
So a question for you. If there's a failure by either side to present evidence of the tax consequences, does your argument still work? In other words, if neither side presented how it would affect them by way of bottom line dollar and taxes, does your math, again, not the greatest mathematician here, but does your argument still, the inequity between what each of them was kind of bringing to the table, still render your argument valid?
I believe it does. I am also not an expert in tax and the tax implications of this, but the income that is used for the calculation came from husband's wages and other income that he was drawing from the business as the business owner, as a shareholder in the business. And so that gap still bears out. The wife is only receiving around, $200 in wages from her job part-time at Market Basket. And furthermore, I would say that the trial judge also not looking just at the income, but needs to look at the other section 53 factors required for alimony, and part of that is the contribution of the parties to the marriage, the health, employability, and the trial judge made findings there that wife had very little ability to increase her income through employment, made findings that the wife's health also significantly impacted her ability to work, and that was due to heart problems that she suffered from pregnancies during the marriage. In terms of contributions to the marriage, she was the primary caregiver and homemaker because she was not permitted to work outside the home, and that also contributes to her ability to improve her station because she has this long gap in her resume, a lack of fluency in English, and all of that should have also factored into the way the court decided to make this decision of alimony and how to weigh it. And so I think what is clear is that the current award as it stands is inequitable because, again, it leaves the wife significantly worse off than she would have been under traditional alimony principles, and doesn't take into account these other key 53A factors that the court should have weighed. Additionally, I think the difference between the parties is even more drastic when this court considers that the trial judge miscalculated Mr. Rao's income for purpose of child support and alimony, and so that's the second issue, where the trial court significantly underestimated Mr. Rao's income from wages and also failed to impute additional income from Mr. Rao's use of the business account for his personal expenses and other cash deposits he received. And so facts on the record show that Mr. Rao was making well above minimum wage as a franchisee owner. At trial, he was paying himself $500 a week for 15 to 20 hours of work, which results in a wage of $30 to $33 an hour. Yet despite this, the trial court chose to estimate the additional income he could earn by using a minimum wage of $15 an hour, which is clearly outside the range of reasonable alternatives and therefore an abuse of discretion. And in creating a range of reasonable alternatives, the trial judge could have looked at factors such as, again, husband's work history or his earnings history. The case before us, the trial judge was presented with JR's payments from 2019, 2020, 2021. And so if the trial judge wanted to take a 3-year average of income, then JR's income from wages would have been at least $48,000 a year, or roughly $23 an hour if you assume a 40-hour work week. But every measure shows that the band of hourly income should have been above that 15-hour minimum wage that the trial judge chose, and that's outside the range of reasonable alternatives. On top of that, Mr. Rao also had several sources of additional income that the trial court failed to impute to him. And so JR used the Manmohan business account to fund his personal bank account and pay expenses on 2 personal credit cards. And the child support guidelines tell us that income should be broadly construed. Section 1D speaks about in-kind payments or benefits received by a parent, personal use of business property, and payment of personal expenses by a business in the course of self-employment, if such payments are significant and reduce personal living expenses. And the trial judge was presented with evidence on the record that JR was drawing upon an average of $26,000 annually from Manmohan's business account to pay personal expenses, and received an additional average of $19,000 a year in deposits from undisclosed sources. And there's no mention of this within the findings. The lower court failed to factor these amounts into its calculation of Mr. Rao's income, or at least discuss why it discredited. If it were to not credit that amount, there's no discussion of it in the findings, and so that's also an issue. And so in conclusion, between JR's wages, personal use of business funds, and additional cash deposits to his personal account, the average weekly income should have been about $2,000 weekly, which is about $800 per week more than what the trial court calculated. And again, goes to that determination of the gap between the spouses and JR's duty and ability to pay, and why alimony, in light of that, would have been the fair and equitable call. Lastly, the trial court made a clear error in its valuation of the marital estate and its decision to present Ms. Rao with only half of it. And so the first issue here is that the court did not properly consider all the mandatory Section 34 factors in its equitable division of the marital estate. And so one thing to point to here is that amount and duration of alimony is a Section 34 factor that a court must consider when dividing the marital property. And so if the court were to decide, as it did, not to award Ms. Rao alimony, then it should have factored that into how it then divided the marital estate, but it didn't, and so it doubly deprived her. The court also failed to fully consider the conduct of the parties during the marriage and the opportunity that each had for future acquisition of capital assets and income. So the trial judge found that Ms. KR's homemaking contributions allowed JR and his parents to work and save money to buy the business that is the key part of the marital estate. And during that time, she cared for the home and the children. KR was subject to significant domestic violence and abuse. Despite those findings and the court's findings that the entire business would likely pass to JR through his inheritance because his parents owned the other 40% of the business, it awarded KR only half of JR's share. And so that half represents only 30% of the business's entire value that she contributed to and made possible. Additionally,
Likelihood to inherit the business is an expectancy, it's not vested.
yes, it's not vested, but there have been cases such as, I think, Zay that says that expectancy is able to be considered by the court within this category of opportunity of each for future acquisition of capital assets and income.
And what's your best case for that proposition? I'm sorry.
Zay versus Zay.
From this court, 1993. Got it. Okay.
Yes. And I would also add that the lower court noted that JR was able to earn income from his profits as a majority shareholder in the business, and even says that the evidence reflects that the business has greater value as an ongoing source of income than it might have if it were sold, yet it did not count any of JR's shareholder income for the purposes of alimony and child support because it viewed that as part of the marital estate division. And if we are to credit the trial judge's decision that that majority shareholder income should indeed, be tied up in the marital estate division, then that should also have factored into how much the trial court awarded KR, and a simple 50-50 cookie cutter approach clearly doesn't account for that. Lastly, the valuation of the business itself was in clear error. The trial judge credited witnesses for 7-Eleven franchise issues, but notably did not credit anyone as an expert on business valuation, and so, it had to reach its own valuation. But our position is
How is
that
that an error, though? Isn't credibility of the witnesses' testimony lie within the province of the?
yes, the trial judge is definitely allowed to credit the witnesses of the testimony. Our issue is that I believe it's Bernier that says that when, so valuation of the business, question of fact, but when the judge is not allowed to disregard the totality of the circumstances in reaching their valuation, and that is the issue that's happened here. And so judge certainly could credit whichever witnesses he chose, but there was also additional evidence presented from a witness that he chose to credit as a 7-Eleven franchisee witness. That same witness testified to selling a similarly situated 7-Eleven for $150K, and so that should at least have been the value of the business
No,
here.
we're going to leave it there.
Thank you.
Do you have any questions for JR?
I do not.
Do you have any questions?
I do not.
No, all right, okay, we'll take the matter under advisement. Thank you all.
Thank you both.
We're going to take a short recess.
Court all rise, please.
Our next case is 25P133, Department and Children and Families versus Children and Others. As you all know, this is impounded, so please do not use names, instead titles or pseudonyms. Ms. Hopel.
Yes, thank you, Your Honor. Good morning, members of the panel. My name is Natalie Hoppel. May it please the court, and I represent the appellant children in this appeal. Your Honors, my clients are requesting that this court vacate the termination decrees as well as the Rule 60 decision. In support of their request, I'd like to focus on two key issues from our brief, which is the reinstatement of parental rights and the ICPC. Your Honors, in these circumstances, the children are institutionalized legal orphans who have not achieved permanency. My eldest female child client is now 12 and can withhold her consent to adoption under GL Chapter 210, Section 2. The children, albeit in an institutionalized setting, are placed together. Reuniting my clients with their father is a common sense option that the lower court should have considered. The all or nothing aspect of permanently terminating parental rights is no longer an absolute in the United States. As of today, more than 50% of the states have codified varying approaches to the reinstatement of parental rights, which tells us that the majority of states have recognized that the least detrimental alternative approach to child welfare decision-making serves the best interests of the children. Recognizing that not all children's best interests are served by the permanent termination of parental rights is a child-centric and child-specific approach. These children are institutionalized legal orphans. Their best interests are not served by maintaining termination decrees for the sake of termination decrees. Setting down.
Let me interrupt for a moment just because I know we have limited time and we're all sharing the time. Can we get to the issue about the ICPC placement?
Yes, Your Honor.
Was that raised below?
Your Honor, it was not raised below by the trial counsel, but I would offer to the court that where it wasn't raised below, it's still a live issue on appeal, given the arguments that I've attempted to make in my brief on behalf of the children, arguing that because the ICPC, as it's implemented, does not allow parents and children to appeal decisions in the receiving state, that's a fundamentally flawed way of placing children across state lines.
But isn't that, in my mind, two separate analyses? One is when a department is looking at another state, in this case, Mississippi, right? And to say, check out this home, right? The second is, are you a fit parent, right? And so with one, if we're considering, as the government, terminating the rights of a parent to a child, the right to counsel it is absolutely undeniable. When it comes to an administrative proceeding as to how many bedrooms, how many bathrooms, is this a stable house, or what have you, seems to me to be different. And here you're claiming on an issue that wasn't raised below, what, that the kids had a right to counsel on a home placement or a
Your Honor, if I may try to answer your question. In terms of the idea that the mother in this case was the placement as opposed to a relative, her fitness is intertwined with whether or not the ICPC is approved. I'm not aware of circumstances, if any of all that I've experienced, where if an ICPC is denied, the department will override the ICPC or the court will override the ICPC and place the children in that destination or receiving state.
I'm not talking about the practical realities if one doesn't happen than the other one. I'm talking about the different rights and the different focus. And not that it's standing, but the priorities. You're saying that the children here, if we were to agree with you, had a right to have an attorney represent their interests when Mississippi evaluated mom's home in Mississippi, right?
I think it's if because in this particular circumstance, the ICPC on their face, both of the forms, they first say approved, then they say rescinded. So there was an overriding decision that the state agency in Mississippi made where they first approved the ICPC, then they overrode their earlier decision, struck that language out and rescinded it. In that type of a circumstance, normally you would have a right under the Administrative Procedures Act of a particular state to go through and appeal the decision-making in that destination state. That didn't happen. So it's a very particular set of circumstances in this case where a state approved and then denied. And the idea that the children were never, ever considered as being possibly movable to Mississippi, in terms of practicality, in that situation, mother, because she moved to Mississippi, she was not in a position to demonstrate her parenting capacity to the court or to the department, which gives rise to the argument that because you could not appeal what the state of Mississippi decided, Massachusetts regulations, on the one hand, you can somewhat do an administrative appeal, but then they defer to what the receiving states decided. So really, there is no mechanism by which you can appeal. And then in terms of appealing through the Administrative Procedures Act of a receiving state, you do not have a right to counsel in that state, and I think that that is problematic. The ICPCs recognize that. There is proposed language in the ICPC statutory scheme that the states have agreed to amend it to give appellate rights, but we're not there yet. There are no present appellate rights in terms of an ICPC. And I can continue, or I can... Thank you, Your Honors.
Thank you. Ms. Sullivan-Puccini.
Good morning. May it please the court, Sharon Sullivan-Puccini, and I represent father. I'm going to talk about the Rule 60B motion. I first want to talk about the discretion of the trial judge. And
Is this just a 60B6?
Yes.
Thank
yes. You. My first argument has to do with a discretion and how the judge used the wrong, she cites to Georgette, but what we should be looking at is the factors of her weighing, the weighing of the factors that went to her decision. And I cite in my brief Yvonne, which says if they're not using the correct standard, then you don't need to give her decision deference. So the judge's decision was focused on finality and delay. And the delay in this case should not be attributed to father.
Can I ask you, why do you say that? I obviously read the decision, and I see the language in there about finality and delay, but I certainly don't understand your characterization that the judge's decision was focused on that. In fact, the opposite. I see quite a bit of detail about why, while laudable, the father's change circumstances weren't frankly extraordinary, anything that wasn't generally known at the time when she made the determination of unfitness.
For the father. Okay, so I'll go right to the father's fitness. But the circumstances here, they're not, for the 60B, were not just father's fitness, they were also, which is very important, were the children's status as legal orphans. Their permanency had disrupted, and they had their prospects of being adopted.
I read the single justice's opinion several times. I'm sure you did as well. And it appeared to me to be very narrowly tailored for the judge to determine in whatever fashion the judge saw fit whether the father's circumstances.
But a father's circumstance is, and what we're looking at, and if you look at the order, she specifically says, the rules, motion limited solely to the issue of the father's current circumstances justify relief from the decree. It's a termination decree that has to do with the child's best interest.
By definition.
You always look at the child's best interest is always paramount. And what I think might have happened with this whole, with DCF's argument that you can't consider anything else except the father's circumstances, is because the mother had wanted to join in as well for the 60B, but the judge, the single justice said no. It's just the father's circumstances. So I think it's very distinguishable. And then you have to look at all of the factors that for this 60B, and it has to do with the material and substantial change in circumstances for the father. And at the time of trial, he had only been, in January of 2003, he had only been sober for 5.5 months. At last October, when we had the hearing, he had 2 years of being clean and sober. All his drug screens from 2023, 2024, they were negative. He had, at that time in October of 2024, he was living in an unstructured program called the Graduate House, which was part of that North Cottage facility, which is a long-term facility. And what they teach them there is how to learn to live as a sober life. And if the judge had allowed the witnesses to testify, and they were in the hallway, they had been subpoenaed, and they were there, they had written letters to show how he had been successful, their testimony would have demonstrated that strong recovery foundation that the managers, his counselors there, would have demonstrated. But the judge did not allow us to have the witnesses. Her focus on delay and finality was, it was almost like the case is done and let's move on. But the case is not done when the children have nowhere to go. They have no permanent place to go. Why should we terminate when the children are living in a locked facility, St. Vincent's, and they are together, but they only see each other, at lunch or at the dinner time? And the judge made findings that these siblings are bonded. Unfortunately, at the time of trial, the son was in a pre-adoptive home. And so the decree came out in March of 2023, and then just months later, by June, his placement, the foster parents didn't want to adopt him anymore. So now this boy is in St. Vincent's. The daughter never had an adoptive home. She had someone that wanted to possibly adopt her, but that never happened. So these two children are living with no chance of being adopted. The daughter's already 12 years old, and the statistics of them at their ages, 9 and 12, of being adopted are very slim. I see I have 14 seconds, so I'm gonna wrap it up. But what I would like you to look at this case and really think about the children, because it's not just the circumstances. And Justice Walsh, you wrote the Osborne case and you talked about legal orphans, and these children deserve a chance, and I hope this court gives them the opportunity. I will rest on the rest of my brief and ask that the court vacate the termination and set forth a reunification plan for these children. Thank you.
Ms. Driscoll-Weiss.
Thank you. Excuse me. Good morning, and may it please the court, Roberta Driscoll-Weiss on behalf of the mother. I had planned to argue the issues in my brief, but if I could address your question, Justice Walsh, why this court should address the issue of the ICPC if it was not raised below. And this is an argument that I make frequently before various panel of this court. If we agree, and hopefully we all do, that the right to parent your children and the children's right to be parented by their parents is one of the most important and, dare I say, sacred rights that we all have, then this court can address any and all issues it sees fit that might contribute to a substantial miscarriage of justice. I believe it's adoption of Mary that says that. I do not think this court is limited in the matters that it can raise, whether we brief them or not, quite honestly. So I would say that the issue of the interstate compact on the placement of children is very much an issue of a substantial miscarriage of justice, because as you heard from my sister, there is no right of appeal to those decisions. And so an out-of-state agency, or the agency of another state, but not the Commonwealth of Massachusetts, makes a determination that essentially forecloses mother's ability to have these children placed with her, and she has no remedy for that fact. So I would offer that as an answer to your question. If I could just point out that this is a case where DCF decided early on what the issue was, that the issue was that one of the children had been sexually abused by a particular individual and held it against mother forevermore when mother did not align her beliefs with those of the department. But I will point out that, and this is not to question the validity of the child's disclosure of sexual abuse, I'm not questioning that it happened, only to point out that the child identified 3 different perpetrators in the course of her various disclosures, but DCF decided early on that mother's husband was the perpetrator and forevermore held it against mother when she did not agree. DCF, in fact, did not investigate the child's statement that it was, in fact, an ex-boyfriend of mother's. DCF was aware of this information, chose not to investigate it, but still managed to consider it de facto evidence of mother's unfitness that she would not agree that her husband had been the perpetrator. Nonetheless, by the time of trial, mother had separated from that individual, was living in another state in a home that she owned, there was absolutely no evidence of ongoing substance abuse by mother. And so as I'd argued in my brief, I would urge this court to vacate the termination decree against mother because at the time of trial, there simply was no evidence of mother's unfitness to warrant termination of her parental rights, but
We're
rather...
going to have to leave it there. Thank you.
I'm done. Thank you.
Ms. Gallup.
Good morning. May it please the court, Julie Gallup on behalf of the Department of Children and Families. The department filed a motion to strike in May and to strike many of the arguments that the appellants have advanced regarding the current or the alleged current status of the children. The single justice's order was clear that they could pursue a 60B motion based on father's changed circumstances and that restricted the trial court's consideration to those. In the face of that order, father and children filed a joint motion advancing several different arguments that about post-judgment developments with regard to the children. Now, I know that my sisters have filed an opposition to that motion yesterday, and they say that the department opened the door by filing a court report at that time of that hearing. The department is required to, at every hearing, file a court report, so I would say that is not, the department was not trying to advance that issue, and instead the department did oppose the 60B motion, and at argument on that motion reminded the trial court that the appropriate forum to litigate the children's permanent plan is the 29B hearing, Chapter 11929B. The children retain trial counsel. The 29B hearing, after that hearing occurs, they can appeal that. So the court retains active oversight over their current status and permanent plan. So all of these arguments about, what their current status is, I would say, are not properly before this court. Now, with regard to the issue of waiver for the ICPC, my sister cited the substantial miscarriage of justice as a way to, for this reviewing court to approach a waived issue. Now, my understanding is, based on care and protection of Doretta, a footnote that in care and protection cases, most civil matters, we don't use the substantial miscarriage of justice. It's only in cases that are criminal or quasi-criminal where the standard is proof beyond a reasonable doubt with regard to civil commitments, I think sexually dangerous persons. So I would say the issue is waived. They had an opportunity to present evidence at the time of trial about mother's current fitness. The fact that the ICPC placement was denied did not preclude her from presenting any evidence to say, I'm ready and willing and able to take care of these children. And I'm not saying that that shifts the burden onto the parent, but that The judge has to make an independent determination as to fitness. The fact that another agency in another state denied the placement, I believe, a year before or 6 months before, does not, alleviate the judge's obligation to make an independent assessment.
But, I mean, you'd have to agree, counsel, is a point where if an ICPC is denied, how long have you been doing this work for?
I don't know.
How many years?
6 years.
Have you ever seen a case where then a judge in Massachusetts, for example, will say, you're a fit mom, you're a fit dad, you get custody? I mean, there is some interrelationship between, in other words, between a denial by the ICPC of a particular home situation and ultimately a finding of unfitness. Isn't there some connection?
Well, I would say the judge is not allowed to transfer any sort of analysis of a parent's fitness to an agency, to another person.
Not suggesting.
And that, and I don't believe that the judge's findings reflect ultimately that the denied ICPC was the crux of the mother's unfitness. In fact, I believe the judge recognized that there were ongoing issues. Basically, all of the issues that plagued the parents at the beginning of the case continued to persist at the time of trial. The judge made an independent assessment. I do not read the judge's findings.
Not suggesting that the judge didn't make an independent assessment or that the judge can decide to rely upon an ICPC, not at all. But have you ever seen a situation where another state denies a home plan and a judge in our state says, you're a fit parent, custody is granted?
I don't know if my anecdotal observations.
So my point being is that there's some heft, isn't there, that as a practical matter?
I don't agree with that at all. I believe the department presented sufficient evidence regarding mother's ongoing unfitness. Mother maintains that after she relocated to Mississippi, that all the problems that plagued her when she was in Massachusetts disappeared. In the face of the fact that we have 6 mental health coded calls that the police had to respond to, mother was not engaging in any sort of substance use treatment. She said she was going to NA meetings and the person that was giving her a ride then relapsed. There was a history of issues that continued and that the failure of the Mississippi Child Protective Services to find the home an appropriate placement. I don't believe that does not appear to figure very strongly in the judge's findings, which support the ultimate determination of unfitness. Now, with regard to the 60B motion, I don't believe that the judge abused her discretion in denying father's request, even though I believe that the father and the children ignored the single justice's order to tailor the motion in a very specific way. The judge, in her order, reminds us that the 60B motion is not basically a review and redetermination post-termination of parental rights, and that is essentially what was happening here. Father had, at the time of trial, 5 years to engage in services and demonstrate that he was able to take care of 2 high-needs children that he had never independently cared for. He then comes back 18 months later and says that I've addressed one of the issues of many that, rendered me unfit. And I don't believe that the judge, it's an abuse of discretion. I don't believe there was an abuse of discretion to deny that motion. I believe I addressed as many of the arguments as I could in my limited space in my brief. If there are no further questions, I would rest on that.
No, thank you. Thank you all. We'll take it under advisement. Our last case is 24P 1005, Garrett Healy and another versus East Boston Savings Bank and another. Mr. Grant.
Good morning, Your Honors. May it please the Court. Steve Grant for the appellants. It's undisputed that this real estate project was in financial turmoil, and it can't be reasonably...
Can you move the microphone
pardon
closer?
me. And it can't be reasonably disputed that the bank was actively, directly looking for a buyer to save it, and ultimately relied on my clients to save it. And they did find a buyer, one that in the bank's own words called it the best deal we could have got. So the question here is, why shouldn't my clients be compensated for their services? They proffer a number of theories of recovery individually and jointly, and the defendants offer a number of defenses, many of which we feel were waived.
So how was the statute of frauds affirmative defense? Let's start with that. I understand your argument that they waited 4 years before they filed an answer.
5 years, yes.
5 years. Did you move to strike it?
I did not at the time.
Okay. What authority do you have for the proposition that an affirmative defense asserted in an answer that has taken some time to be filed is invalid or waived?
Primarily when there's prejudice involved. For example, in December of 2021, technically after the close of discovery, I was finally able to depose the vice president of the bank. 3 weeks later, they filed their answer, including statute of frauds, not the other affirmative defenses they asserted in their motion for summary judgment. I feel that's unfair, at best. At worst, bad faith. Not with my brothers present here today. This was former counsel, Attorney Patrick Dolan. That defense wasn't on the table. It hadn't been. I had no notice of this defense throughout discovery, certainly not at the time of that deposition. I would have asked Mr. Migliozzi, was anything signed at the meeting you had with my client?
But I'm sorry.
No, go ahead.
If you had a signed agreement, I could understand perhaps some prejudice, but there's no signed agreement.
My client couldn't submit one. We did ask for, or certainly I could have asked for the vice president. Do you have any? Was anything signed the day of the meeting? Were there any emails that could constitute some type of an agreement?
How much time elapsed between the filing of the answer and the motion for summary judgment?
I want to say a year, over a year and a half.
So that was a lot of time to look into those things.
It was.
So, but I just want to go back to my question. I understand you're suggesting it was unfair. What case or legal authority do you have for the proposition that an affirmative defense asserted in an answer that was filed years, in this case, after the complaint was filed, is waived?
For example, I think O'Donnell v. Bain touches on lateness of affirmative defenses filed.
What was the name of that case? O'Donnell versus Bain.
Yes, for example.
What specifically does that case say about the issue I just raised?
Your Honor, if I may, I'll give you perhaps a better case, Leonard v. Brimfield, where in that case it upheld the denial of a motion to amend a complaint, but I feel it's analogous. Although the case was not actually tried for 17 months after the denial of the motion to amend, the case had been pending for over 5 years, and the judge believed the trial was imminent.
Right, but in that case, a motion was put forth before the trial judge, before the judge in the Superior Court or whatever trial court they were in.
Mm-hmm.
There's no such motion here before the trial court, so you're coming to us in the first instance. I don't know that an appellate court has the authority to do this, to do what you're asking us,
well,
where there's no rule on point. My question might be poorly articulated, but do you understand what I'm asking?
I do believe I know what you're asking. I guess I would say that, you know, an affirmative defense is, and there is case law on this that I believe I cite in my brief, that after a certain amount of time, a defense is waived. And I don't think if the onus is on the plaintiff to move to strike it or
I believe it is. I mean, if it's, affirmative defenses are typically asserted in an answer, or they can also be asserted at summary judgment. But if you felt at the time that, hey, this is unfair because now I'm just getting notice of this for the first time, the onus is on counsel or is on the party to move to strike it. Because otherwise you're asking this court to sit as basically a court of equity and say, hey, we kind of feel that's unfair. That's really not within our powers.
well then, I would move to the alternative argument that Mr. Healy was in a joint venture with Mr. McQuaid, a licensed broker. The bank knew this. The appellees point to what I feel is an irrelevant statute that says if you're a licensed broker and you work in a corporation, LLC, entity, or whatnot, then you can't perform, that is not licensed, well, you can't do that. Here, there was no such entity. You have an auctioneer, licensed auctioneer, and a licensed real estate broker working hand in hand, which is, by all accounts, common practice. And that's one way we would get around the statute of frauds case. It was clear to the bank they were working together. Mr. Healy and Mr. McQuaid submitted an offer to purchase to the bank, as well as to the title owner. Their affidavits say as much. And statute of frauds is just one affirmative defense. They never raised any of the other affirmative defenses until I was served with this summary judgment motion. Unenforceability, illegality, public policy, nothing was asserted until that time. And also, unclean hands was raised as to McQuaid's claim. First I ever heard of it was on that motion for summary judgment.
So you agree that someone who is a licensed auctioneer can't broker real estate, correct? Can't be a real estate broker.
Correct.
Okay. And so I'm trying to understand how being a joint venture helps your cause because, for example, we're all familiar with the requirement of the practice of law. So just because you add somebody in there who's a lawyer, but that the person is doing the work is a non-lawyer, they can't just appear in court and make a legal argument because they have a lawyer with them or everybody knew that there was a lawyer, right? Isn't that the same, in essence, reason why we only allow licensed real estate agents to deal with the sales of property? You have to go through and be professionally licensed.
Well,
So joint venture doesn't seem, to me, it means you're getting around this requirement that is there for a reason. Tell me why that helps your case. It seems to me like I'm not sure how it does. Tell me how.
Well, in a joint venture, your duties are delegated. It doesn't mean that Mr. McQuaid was performing the duties of an auctioneer or Mr. Healy was performing the duties of a broker. They were both performing their respective.
But there was no auction, right?
There was. Technically, there was no auction where you have the gavel. It never got to the point where there was a public auction. There was no
auction.
There was
no auction.
It depends on your definition of auction. There are different types of auction. There's a live auction, auction on reserve.
There's an auctioneer operating as an unlicensed broker. Is that an auction?
No, but an auctioneer operating as a licensed auctioneer. I think this is why the legislature made this distinction. Section 112 RR says you can't, you have to have a license if you're going to act as a broker. QQ says unless you're acting as an auctioneer.
Yeah, it says, but that means that you get compensated for being an auctioneer, not for being, it doesn't grant them license to be, it doesn't provide license to be a broker.
Well, inherent in both of these professions there's so much overlap. You have to seek out your network of investors, market and advertise a property. My client put it on its auctioneer website. And I think this is the very reason why the legislature probably made this distinction, because they do have such concurrent duties.
But doesn't it contemplate that it actually gets to an auction?
I don't know that, I don't want to speak for the legislature, but what happens if an auctioneer is performing his duties in a completely different hypothetical, he's doing all the work that my client did, and then the seller cancels the auction? There's no public auction. So all that time, all of a sudden the auctioneer is deemed to be working as a broker? There's a lot of preparation. You don't just show up one day at the property and collect oral bids. So, and again, I think that's why the legislature specifically made an exception for auctioneers.
I'm going to back up onto the joint venture. How does the fact that you claim there's a joint venture, which I'm not clear that's supported by the record, how does that get you around the statute of frauds?
Because
there still has to be a writing.
Mr. McQuaid.
What's the evidence that that the bank dealt with anyone other than Healy?
There was my client's, Mr. McQuaid's affidavit. He walked the property with Vice President Mr. Magliozzi and the buyer. They went over the plot plan, the financial. They worked together. That I don't even think is disputed. My brother could correct me, but.
Well, that was with the buyer, though. I mean, the best evidence that I saw in your brief was that he walked with the offer with the buyer.
I think my client's affidavit, too, make it clear that Magliozzi had communications with both Mr. McQuaid and the buyer, Mr. Babago.
Do you think the emails between Healy and the bank sufficiently protect you from a statute of frauds?
I think it's debatable, And then we also have the question of McQuaid's claim for quantum merit, individually, aside from Mr. Healy. He met the elements required under a theory of quantum merit. Even the lower court agreed he conferred a measurable benefit on the bank. I think that the bank, Mr. McQuaid reasonably expected that he would be paid. He was.
So the bank lost almost $2 million in this. So how is that a measurable benefit? Because they didn't lose $4 million?
Well, as I said in the lower court, half jokingly, you can lead a horse to water, but you can't make him drink. This is what the bank wanted. The bank wanted this. They wanted someone to at least give them the chance to save the property. Now, it ended up, after the fact, the project tanked, okay? But that can't be my client's fault. They got a buyer. They were satisfied with the proof is in the pudding. They accepted the deal. And if there's any question that the bank was seeking a buyer, you go back to shortly after Mr. Healy's meeting with the bank president, he arranged for a meeting with the first potential buyer, Mr. William Tebow. They went to breakfast together. The documentation, I think in the appendix 864 to 867, you have a deposit that Mr. Tebow submitted to the bank. He ended up backing out of the deal, but it's clear.
Well, McQuaid knew that the bank didn't own the property, right?
He was ultimately informed that.
And what evidence was there that McQuaid had some communication with the bank about a commission?
He didn't, and nor did he need one.
Why not?
The defendants, the appellees say, oh, well, how could there be quantum merit here? And the lower court judge said, there was no communications about payments. First of all, the case that I relied on, Fernard, did not rely on the fact that there weren't any commission payments. But take the maybe somewhat common example of a homeowner who hires a landscaper. And the landscape for the first time, and the landscaper shows up and he starts performing work at the wrong house. And the homeowner's looking out the window and seeing it. There's no communications there between the benefited other homeowner and the landscaper, but the law would protect the landscaper in that instance. In terms of the payment of commission, quantum merit says that the payment would be the reasonable value of the services. So it's not like it's critical that you have to just.
Let's go back to your landscaper analogy. If the landscaper unilaterally makes a mistake about which house he's at, you think that the law would compensate him because of some benefit to the unknowing landowner? What if the landowner had come home and it was that the work was done, he had nothing, he had no idea what was going on? Why would he have to pay for that?
Then he wouldn't prevail. But in the case where the neighbor is, this lucky neighbor is watching the landscaper put down a stone wall, mow the lawn, trim the bushes, of course, the quantum error would definitely come into play there. Conduct of the parties is also
Thank you. We're
critical.
going to leave it there.
Thank you, Your Honor.
Mr. Nesgaz.
Good morning, Nick Nesgaz on behalf of Rockland Trust Company, a successor by merger to East Boston Savings Bank, and I'll try to be brief today. All of the claims that were asserted in the underlying litigation were properly dismissed by the Superior Court on summary judgment. With respect to Mr. Healy's claims, all of those claims were properly dismissed and had no merit based upon both the real estate broker's license statute, section 87 RR of Chapter 112, and the statute of frauds. As the justices have mentioned, the joint venture agreement, that allegation fails for three independent reasons. One is it doesn't get around the statute of frauds issue itself. If to the extent there was a joint venture agreement with respect to real estate brokerage, there was no agreement with Rockland Trust in writing with a joint venture. But independent of that, there's no evidence here that Rockland Trust entered into an agreement with a joint venture. The only evidence in the record is that East Boston Savings Bank entered into an agreement, or the allegation is that it entered into an agreement with Mr. Healy, who was not a licensed broker. And then Mr. Healy sought out the services of Mr. McQuaid to act as a broker on his behalf in what was essentially an illegal scheme. And finally, to the extent that Mr. McQuaid was acting in a joint venture with Mr. Healy, that would be an illegal joint venture because the regulations preclude brokers from entering into joint ventures, associations, corporations for brokerage services.
What regulations?
That's Code 254 Mass 200, Section 11. There's also a case, Your Honor, in the SJC, the Tobin case, excuse me, where a broker is disciplined for engaging in business as a broker.
I'm sorry, you said, because I don't see it cited in your brief, code, is it a CMR?
It is it's 254 Mass ADC 200. And it's also cited in the Tobin case, which is an SAC case, which we cite in the brief as well, Your Honor.
It's 254, so you're citing to an SJC case?
Yes, yes.
It's not cited in your brief, is it?
It is, Your Honor.
Okay, why don't I see it here? I don't see it in your table.
And Your Honor, we'll get that too, but it may be in the context of one of the motions that was filed below, but there is an SJC case directly on point that cites the regulations and disciplines a broker for engaging in brokerage services through a limited liability
If it's
company.
254 Mass, I don't know if that's a regulation that would still be in existence, but in any event.
Okay. But independent of that, Your Honor, the facts here are there was no agreement with a joint venture, and it doesn't get around the statute of frauds issue. With respect to the claims brought by Mr. McQuaid, there is no possible third-party beneficiary claim here because the underlying contract, as alleged between Mr. Healy and the bank, was unenforceable. and the third-party beneficiary stands in the shoes of the original promisee, and so therefore, for that reason alone, the third-party beneficiary contract claim must fail. And with respect to the quantum merit claim by Mr. McQuaid, there are three elements to that claim. The second element is that the party that received the benefit must reasonably have expected to pay compensation to the plaintiff. And this goes to the example that Justice Mead identified of the landscaper who goes to the wrong house. The owner of the home doesn't reasonably expect that someone appearing randomly at their home is going to be paid. Here, there's no evidence that East Boston Savings Bank had any expectation that Mr. McQuaid was performing services for its benefit. There was some indication that Mr. McQuaid was maybe representing Mr. Barbagallo, maybe representing Norchamp, but no indication that Mr. McQuaid was performing services on behalf of the bank. The evidence is there were no communications whatsoever between the bank and Mr. McQuaid. The evidence is that Mr. Healy never identified Mr. McQuaid to the bank as a third-party contractor to which the bank may owe monies, or that Mr. McQuaid was performing services for the bank. Nothing of that sort. So on that second element of quantum merit, there just is no basis for Mr. McQuaid's claims. And ultimately, quantum merit is an equitable claim. It's founded in notions of unjust enrichment and equity. And here, Mr. McQuaid's claims are really based upon a scheme apparently concocted by Mr. Healy to avoid the strictures of Section 87 RR. And for that additional reason, there is no basis for quantum merit, and the underlying courts.
One more question for me, and for the record, Justice Mead pointed out to me that the regulation you cited to is at page 28 of your brief, but putting that aside.
Thank you.
Does the record reflect why it took you 5 years, or your client 5 years, to respond to the complaint in this case?
Yeah, I don't have, again, we're successor counsel, so I don't know exactly why it was that the answer was filed late. It was filed in 2022. But the lateness of the answer is really irrelevant in terms of the affirmative defenses that were asserted for two reasons. One is there was no motion to strike. But independent of that, and we've cited the law, even if a affirmative defense is not cited in an answer, it may be raised on summary judgment if the undisputed facts presented suggest that that affirmative defense has merit and is in play.
In that context, so let's assume, for example, there was an affirmative defense pled, complaints filed in 2018, answer and affirmative defenses are pled in 2019, and in 2025, for the first time, an affirmative defense is pled and referenced and argued in a summary judgment motion. Would the judge in that situation have the discretion to not consider it or to exclude it based upon a late disclosure?
Not in the cases that we've seen, Your Honor, not in the Shea case.
I would think the answer might be yes, subject to a motion to strike.
Yeah, I think that if the context is that there has been no answer filed, it may be yes, but...
In the hypothetical I gave you, an answer was filed, but the affirmative defense wasn't pled. Then years later, in the summary judgment motion, for the first time it's raised.
Yeah, I think
that would be within the judge's discretion to exclude
it. May be, Your Honor, in the cases that we have seen and that we cited, it wasn't analyzed as a discretionary issue. The cases say simply that...
the judge had the authority to consider it and act on it.
Had the authority to do that, and that affirmative defenses may be raised.
Maybe, right.
May be raised in the context of summary judgment. But, of course, here we have an answer that was unfiled that had that defense, and so I don't think it's really an issue in any event. So, unless there are other questions, I will rest.
Just briefly, on the 87RR, they claim that they're exempted out of the QQ, because he's an auctioneer. Why isn't that right?
Because as Judge Feeney indicated in the other case, the Norchamp litigation, that statute exempts auctioneers acting as auctioneers. That's the language of the statute. And here, on the undisputed facts, Mr. Healy was not acting as an auctioneer. He was attempting to act as a broker and attempting to get around 87 RR, as he says, by hiring Mr. McQuaid to be his, quote, broker of record, end quote.
Were both Healy and McQuaid plaintiffs in the Norchamp litigation?
Just Mr. Healy was.
Right, okay.
I think there was a motion to add Mr. McQuaid that may have been denied. And so for that reason, Your Honor, the 87 QQ does not apply here and is not intended to apply here. This is.
But the 87 QQ doesn't have such clear language that you just suggested.
It does have the acting as.
Acting in the capacity as?
What it says is.
Perhaps I.
Section RR, quote, shall not apply to a person acting as a licensed auctioneer. Right. So it's the acting word that we would rely on and the Judge Feeney relied on.
You just added in the capacity.
Oh, I'm sorry. Yeah,
okay.
No, it is acting as a licensed auctioneer. I don't think there's a functional difference between that and in a capacity as, but.
Okay.
Thank you.
Thank you. Thank you both. We'll take it under advisement. With that, I'd like to thank our court staff, my panel, our law clerks, our court officers, the clerk's office, our excellent timekeeper, and we'll stand in recess.